Called, if you would, step up to the table on your right, my left, and we will review the case.
Your Honor,
We're going to do one arraignment first, excuse me.
State of Ohio versus Jason S. Tackett, case number TRD 1742A and B, TRD 152996.
Right, this is State of Ohio versus Jason Tackett, TRD 1742A and B, TRD 15996, and TRD 15, same case, 25.
Your Honor, Mr. Tackett was appearing here and in common pleas court. He had cases going in both courts kind of at the same time, and we had OR bonded him here with the intention that we could deal with where we're going in common pleas court. And when he was OR bonded in common pleas court, a holder from Kentucky popped up. They took him into custody. He went over to Kentucky, was there for about 2 or 3 months. Kentucky released him. He appeared in common pleas court Wednesday. He pled to his charges there. He was given a sentence of community control sanctions with STAR. He's going to report to the jail tomorrow by noon to go to STAR Tuesday. He's going to be at STAR for generally a period of 3 to 6 months. All we have remaining here now are these old review matters. Obviously, he's not going to be able to do anything on those while he's in STAR. What I'd like to ask is to have the warrant withdrawn and have him placed back on the review docket in a date, maybe about 6.5 months out, to give him time to get through STAR.
Okay.
Now, I wouldn't expect it would necessarily take him 6 months to get through STAR, although it obviously can. But if he completes STAR, he can then get in touch with Mr. Cooper or Mr. Major and maybe get some progress on these cases either before a review hearing or maybe even obviate the need for a review hearing.
All right. I will order the warrant to be recalled. I think that's a valid reason for him, for his failure to appear. And I'm just trying to get out on the calendar far enough. To December 8th for review at 9 a.m. And Mr. Tackett, you've got on the TRD 1742A and B case, you owe $549. There's no community service outstanding there, but you can certainly work some of that off on community service. And then on the TRD 15 case, you still have 3 days of community service and $455 left outstanding on that case. So we'll see you back on December the 8th at 9 a.m.
Thank you, Your Honor.
But if you get everything done before then,
I'll come back.
you don't have to come back. Just before you decide not to come back, clear that with Mr. Major, okay?
All right.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Mr. Chair. And get back to program the cooperative this morning. Maybe for a month or two ago. When you go out 6, it's just get the job. There we go. All right. All right, now we're going to do the remainder of the reviews.
Andrew Curry, Benjamin Hawk, Trevor Hodge, Kelly Keever, Buddy Malone Jr., Cody McDonald. Come up to the table to your right.
Sorry.
All right, Andrew Curry. Andrew Curry. All right, this is State of Ohio versus Andrew Curry, CRB 22351, CRA 23464, A, B, and C, CRB 23463, CRB 23291, and CRB 2361. Mr. Curry has been called for. He was cited in court at 9 a.m. Time is now 9:54 a.m. Mr. Curry has failed to appear, and there will be a bench warrant issued. Benjamin Hawk.
Right.
All right. This is State of Ohio versus Benjamin Hawk, CRB 22181, PRC 202041. All right. Mr. Hawk, you, on September 26th of 2022, you were sentenced on the 22181 case. You had 30 hours of community service and $385 to pay in fines and court costs. And on the 20 case, it was November 9th, 2021, 30 hours of community service and $710 in fines. You've paid $60 in fines since 2020.
Well, I mean, I just got out of prison back in March.
Okay. When did you go to prison?
Literally the exact same time I was heard for this. So I was back in 2020. Let's see, 2022
Okay.
or 2021.
All right. Well, you're out of prison now, and I'll need to see some movement on this.
Yep.
Because you've done almost nothing, and these cases are 4 years old, and there's no reason that you.
Yeah, I did 3 years in prison.
So, I'm going to set you another review date for July 11th. And I'm going to order you to have some community service done before you come back.
Right.
If you do not have community service done, I would anticipate the court's not going to look very kindly on that. Do you understand? At 9 a.m. on July 11th, review.
9 a.m. July 11th.
We'll see you then, Mr. Hawk. State of Ohio versus Trevor Hodge.
He's on.
Okay, this is CRB 2379, CLA 2378. Mr. Hodge is present via Zoom today. Mr. Hodge, it looks like you had 30 hours of community service that you had to do originally. You've done them all, and you're down to $381 on your fine left.
Yes, sir.
You're making some progress there, so I will set you another review date for July 28th
Thank you, Your Honor.
at 9 a.m. Thank you, Mr. Hodge.
Yes, sir, thank you.
Kelly Keever,
Yes.
the State of Ohio versus Kelly Keever, TRC 17-1306A and B. And Ms. Keever, it looks like all you have is community service left. That's it. So you've got 30 hours of community service left, 5 days. All your fines are now paid off, and that was a pretty substantial amount. So I will set you a new review date for 7/28 of 25 at 9 a.m.
Date 28th.
July 28th. So I'll need to see some community service. Knock that out so you don't have to come back.
All right, thank you.
Thank you. State of Ohio versus Buddy Malone Jr.
Right here, Your Honor.
All right. This is CRB 25135 and CRB 2533. All right, this is a fairly recent case. Mr. Malone, are you on treatment or anything at this point?
Yes, Your Honor.
Okay, where are you in treatment?
UFR.
United Family Commissioner.
You can approach.
Your Honor, I've got him on the pretrial docket, I'm not sure.
This is also a review, I think.
Oh, okay, I heard
At
it.
least it's listed with the reviews, but it looks
Okay.
like it was,
Well, there were multiple cases, that makes sense, okay, I heard his name.
yeah, okay.
I'm sorry.
All right, that's a very good report. It's a very good report, Mr. Malone. I'm going to set you another review date for July 28th at 9 a.m. And you've got a pre-trial here today as well, so you need to stick around.
Can I ask what that's serving?
The pre-trial,
Yeah.
you'll need to talk to Mr. Smith. He's your
Okay.
your attorney.
All right, and I got community service hours done too. He's gonna fax those in later.
Okay.
All right.
And I appreciate it. You're doing a great job in treatment. That's our first and most important concern for you at this time. But you'll need to hang around here because, like I said, there is a pre-trial for you today, and we would speak with Mr. Smith about that.
Okay.
He represented you.
All right. When did you say my court date was?
July 28th at 9 a.m. Mr. McDonald?
Yes, sir.
This is State of Ohio versus Cody McDonald, CRB 25-190, CRB 13-338, CRB 12-1113. You may. All right. Very short, but very good report.
He's doing well.
On you, Mr. McDonald. You're making progress, which is all we ask. You just got your treatment component. On the one case, $250 in your treatment component. You can work some of that off on community service, but right now I'm primarily more concerned with your treatment than anything else. And you've got a pretty substantial balance left on your older case, your 13 case. Again, treatment's the most important thing right now. We want to make sure that you're well, so you can be able to take care of these cases. So I'm going to set you back as well for July 28th for review at 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Cody Mead, Jerry Morrison, Mary Morrison, William Rice, Buford Jones, Stacy Tackett.
Cody Mead.
He is not here, Your Honor, but I do have a report from him.
You can watch. Mr. Holland, take care of that. This is State of Ohio versus Cody J. Mead, PRC 23-152 A, B, and C, PRD 22-2101 A and B, PRC 22-1690 A and B. Any idea why Mr. Mead isn't here today?
No.
Okay. Well, Mr. Mead you have saved him and given him a reprieve with his good report, so, but I am going to set him back much quicker because I want to see him here in person. So I'm going to put him on for June 23rd.
Reach out to him too to let him know. Thank you, Your Honor.
Thank you. It'll be a review at 9 a.m. on 6/23. Mr. Mead fails to appear, they'll likely be around at that time. Jerry Morrison. State of Ohio versus Jerry Morrison, CRB 25-200. All right, Mr. Morrison, looks like you have a case balance of $375 left. And report coming on your sheet. Well, Mr. Morrison, best report I've seen so far today, even though it's only been a few. So I'm going to set you back July 28th for review at 9 a.m. Excellent report.
Thank you, Your Honor.
Thank you. Mary Morrison.
Yes, sir.
All right, this is State of Ohio versus Mary Morrison, CW 25-171.
Yeah, approach.
You may. All right. Excellent report, Ms. Morrison. Primarily concerned about the treatment. There's $325 that you owe on the case, but I'm more worried about the treatment at this point. I'm going to set you back for review July 28th at 9 a.m.
Thank you, Your Honor.
Thank you. State of Ohio versus William Rice, TRD 18-2548 A and B. William Rice. All right, time is now 10:06 a.m. Mr. Rice was scheduled to be here at 9 a.m. The failure to appear, bench warrant issue. State of Ohio versus Buford Jones. Buford Jones. Time is now 10:06 a.m. Mr. Jones was scheduled to be here at 9 a.m. Failure to appear will be a bench warrant issue. Stacy Tackett. The State of Ohio versus Stacy Tackett, CRB 22475, 10:06 a.m. Ms. Tackett was scheduled to be here at 9 a.m. Failure to appear will be a bench warrant issue.
Ready to arraignment, Charlie.
All right, we're going to start some arraignments. When you hear your name called, come up to the table on your right, my left, and I will go through the charge with you. Now, you have the following rights before the court, and I know you heard them on the video, but I'm going to go through them with you again. You have the right to remain silent. We are recording everything in here, and if you say something that is not good for your case, the State of Ohio can get a copy of that recording and use it against you. You have the right to have reasonable bond set in this matter. You have the right to counsel. If you can't afford counsel, then we can appoint counsel for you if you qualify, and you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. When you get up here, I'm going to go through the charge with you, and I'm going to ask you for a plea. You can enter one of three pleas: guilty, not guilty, or no contest. Guilty means you're making a complete admission that you committed the offense charged. Not guilty means you're denying that you committed the offense charged. And no contest essentially is you're not admitting the violation, but you're not contesting it either. And if I think the state would have enough evidence, I can enter a guilty finding for you in that regard. If you are unsure of what you should do, you should enter a not guilty plea. It preserves all of your rights before the court. All right, we'll start with State of Ohio versus Justin Thomas. The State of Ohio versus Justin Thomas, PRC 25-1274 A and B. Mr. Thomas, it's alleged that on or about May 31st, 2025 in Union Township, that you operated a motor vehicle while under the influence of alcohol, a drug of abuse, or a combination thereof, and you had a breath score of .131. That's a violation of, alleged violation of Ohio Revised Code 451119 A1A and 4511.19 A1D. That is a misdemeanor of the first degree. The maximum penalty on that, it's alleged it's a second offense. Maximum penalty on that is up to 6 months in jail, a $1,625 fine, treatment, up to a 5-year driver's license suspension, and interlock plates, and immobilization of your vehicle if it's registered to you. The minimum penalty on that is 10 days in jail or 5 days in jail and up to 18 days of home confinement. $525 fine, 1 year license, and a 1 year license suspension. It's also alleged that you were speeding, and that was 55 miles per hour in a 35 mile per hour zone. It's an alleged violation of Ohio Revised Code 4511.21C, and that is speeding. It's a minor misdemeanor. The maximum penalty for that is $150 fine and court costs. How do you wish to plead?
No contest to the OVI and guilty to the speeding.
All right, well, I will accept your guilty plea on the speed and enter a guilty finding on that, and it'll be a $100 fine and court costs on the speed offense.
Your Honor, do I pay that at the clerk's desk today?
You do. However, I want to make sure before you enter a no contest plea on the OVI, I want you to understand, if you enter a no contest plea, I have to put you in jail.
Today? Not guilty.
All right, I thought that might be what you would want to do. So I'm going to go ahead and withdraw your guilty plea on the speed as well. We'll deal with it all at one time.
Very well, sir.
Are you currently, can you afford to hire an attorney on your own?
No, sir.
Okay, are you working?
Yes, sir.
All right, are you paid by the hour or your salary?
Paid by the hour. I'm a bartender, so it
Okay.
varies.
Do you know what you made on your taxes last year?
No.
Okay. What's your hourly?
It varies so wildly, it's hard to determine. I would have to say average 15.
Okay. How many hours a week do you get?
Ooh, not much. 10.
Okay. I'm going to find that you qualify for appointed counsel. I'll appoint Attorney Luke Steyer to represent you.
Your Honor, I have a few acquaintances and a means to be able to work off my debt with other folk. I probably would seek counsel of Mark McCown.
You can do that if you wish, but for the time being, I'm going to appoint
Very well,
Mr.
sir.
Steyer. If you wish to hire
No
your
offense.
own, you're still welcome to do so.
Very well.
And I'm going to set you a $1,500 signature bond, OR bond. That means you're signing saying that you'll come back to court.
Okay.
And we're going to start with Mr. Steyer's schedule. Mr. Steyer, when would you like to come back?
I didn't hear if there was a test in this case and what kind.
It looks like it's a breath test.
Not good for
and
me.
it's a .131.
Don't say anything like that, please. I am going to be out of town for about a week, so if we could go to the does Monday or Friday matter to you? Okay. Let's go to the 27th if we could, if that's when you're setting things, or are you going out further than
We can
that?
do June 27th
Okay.
at 10 a.m. and that'll be a pretrial. Right here. And Mr. Thomas, it will always be here, so.
Very well, sir.
If he has a fingerprint, he needs to be alert.
Were you
I
arrested?
believe the fingerprints are in the file.
He says he didn't go to the jail, so he probably does need to be fingerprinted.
Okay.
Unless you find a fingerprint card in the file.
I do not have one in the file, so Mr. Thomas, you'll need to report to the Lawrence County Jail to be fingerprinted.
Is there a written order that he takes? Or anything of that nature?
A copy of the bond sheet will have that is required on the
Okay,
bond.
all right, so,
This is all new.
right, they've just started doing this, so I don't really understand exactly how the logistics work. So what I'm gonna have you do is just wait for me in the lobby, I'll get your file in a couple minutes, come out and talk to you.
Very well.
Okay, thank you.
Thank you, Mr. Thomas.
I had someone go and get fingerprinted, and they gave them the card, which is probably not what's supposed to happen, which is why I wondered if we had something going with them in the future.
Okay.
Did you say that?
Yes.
State of Ohio versus Garrett A. Childers, case number CRB 24221.
The State of Ohio versus Garrett A. Childers, CRB 2421. Looks like Mr. Childers was scheduled to be here May 19th and failed to appear for his review hearing, and was bench warrant issued at that time. Mr. Childers, do you admit or deny that you failed to appear?
I'm just going to be honest with you. We were cleaning and I threw away the paperwork on accident. And I couldn't remember if my paperwork was or my date was in June or May at that point.
Okay. You've got 18 hours of community service left and you made some payments on your fine. Do you have a payment that you can make today?
I might be able to make $100 today.
Okay. I'm going to put a note then. Now, is it you might be able to make it, or is that you're going to make a $100 payment today?
I really just have to go to my house, get my card and go to the ATM and come back.
Okay, well, I'm going to put on here that you're going to make a payment today.
Okay.
If you don't make a payment today, I'm not putting an amount, but if you don't make a payment today, I'm not going to be very happy about that.
Okay.
Understand?
I got you.
Okay. All right, I'm going to recall the warrant. And I'm going to set you back for review. On June 27th. I want you back sooner than later.
June 27th?
Yes, sir. And that'll be a review at 9 a.m.
Okay.
Thank you.
Have a good one. We're ready to go to the Lawrence County Jail, Your Honor. State of Ohio versus Justin L. Belcher, the Lawrence County Jail, case number CRA 25-1233 A and B, and TRC 25-1265. Mr. Steyer is the attorney.
It's the State of Ohio versus Justin L. Belcher, CRA 25-333 A and B, TRC 25-1265. Mr. Steyer, come in. All right, Mr. Belcher, can you hear me? You may want to ask them to turn up your volume a little bit on your end. Okay, we can hear you now, it's better.
Okay, they got me now.
All right. This is Mr. Steyer's case. It's set for a pretrial and preliminary hearing this morning.
Your Honor, I had discussed with the state the possibility of our recognizance bond for Mr. Belcher to go to treatment. Hometown Recovery called over to the jail to attempt to evaluate him. They were told they needed to call back in about an hour due to the system being used for court. So I'm going to ask to have this recalled a little bit later in the docket.
Okay. Matter will be recalled a little bit later in the docket, Mr. Belcher, did you hear what your attorney had represented to the court?
Yeah.
All right, so they're gonna have an assessment done on you, and then at that point, once that's done, we will recall this matter.
Thank you.
Thank you, Your
Who
Honor.
did you say is on deck?
State of Ohio versus Terry Curley, case number CRA 25332, and Wesley Earls is on deck.
So the State of Ohio versus Herrick Hurd, CRA 25332.
This case.
Mr. Rogers in this case.
Yeah.
All right, Mr. Hurd, can you hear me? You're muted, I believe.
Yes, I can hear you.
Okay.
Your Honor, I know that Megan had called down from QRT, they had a discussion. This is an F5, alleged F5 possession of heroin. I think the consensus at this point is that the state would not oppose an OR bond release to a treatment provider. It's, I guess, up to the court whether it be an ankle monitor component, but how do you pay, when you go to the doctor, how do you pay for medical services? Do you have an insurance card or a medical card?
I don't right now, if I can get one.
Okay, do you live in West Virginia?
Yeah.
Milton? I don't
Yeah.
know who does West Virginia.
Okay. If you would like to do an assessment on her, obviously.
Yeah,
can't do that this second, but
If we find somebody that could do it and call it back up, that would be my preference at this point.
Bethesda said they would do it.
yeah. All right, Ms. Hurd, what we're going to do is we're going to have you assessed for possible treatment. And that will probably take place in the next probably hour or two. So we're going to recall your case a little bit later in the docket after you're assessed, and see if there's going to be a change in bond or if there's a resolution in this matter. Okay? You're muted again. I'll mute her.
We'll have her back.
Yeah, we'll recall that one later in the docket.
State of Ohio versus Wesley Earls, case number CRB 2523, CRB 25132, and Randall Eplin is on deck. Mr. Steyer's case.
All right, this is State of Ohio versus Wesley Earls, CRB 2523, CRB 25132.
But please record, that's Mr. Eplin on the video.
Well, I called Wesley Earls is who we want.
If we've got Mr. Eplin up, let's go ahead and take care of him. Well, never mind.
Okay, they're swapping him out, or we can,
Judge, Wesley Earls is the actor.
oh, I thought he was back, I misunderstood that.
No, sir.
He's in Athens.
Now, can I ask you a question? Is he at Athens on a pink slip, or is he at Athens? Did he come back to the jail and went back to Athens again?
Yes,
So he's at Athens for restoration at this point?
correct.
Okay, I wasn't made aware of that, thank you.
Thank you.
So Mr. Earls then, is that where we are?
Yeah,
Okay.
we'll stick with Mr. Earl since we've already called it now. He has an answer.
This is Mr. Eplin that's up there now.
Mr. Earls is not.
He's not gonna be up there.
Right, Mr. Earls is not going to be up there.
Correct.
So we are on Mr. Earls?
Yes.
Okay. Mr. Earls has a case pending in common pleas court. I've entered an NGRI and a competency issue in that case. He was found to be restorable. We've been waiting for a month or two now to get him to Athens. He's at Athens now. So at this point, I mean, we can put this case back on the docket a little bit later to see where things are. I would say a month would be optimistic. I would say 6 weeks is probably a more reasonable time frame, but if we want to do a month to be safe, that would be certainly fair.
Mr. Hill.
We are in agreement with that, Your Honor.
So I would ask for the 14th of July.
This matter will be continued at the defendant's request and based upon his absence to July 14th. at 10 a.m. for a pretrial.
When is it, Your Honor?
July 14th.
State of Ohio versus Randall Eplin, case number CRB 25307, TRC 242509 A and B, TRC 18666 A and B.
The State of Ohio versus Randall Eplin, CRB 25307, TRC 242509 A and B, TRC 18666 A and B, CRB 17181. Mr. Eplin is via Zoom at the jail. His attorney is Mr. Steyer. Now, Mr. Steyer, we just received this today.
I've seen that, Your Honor.
That was my first question, was, had you seen this?
And where we were prior to seeing that was that Mr. Eplin was awaiting, I believe, an ankle monitor and a bed at Hometown Recovery. I think they had the bed for him, but they were waiting for the ankle monitor, which has not been affixed. However, Mr. Eplin, I don't know if he's aware of this because this came here, I don't know if it went to the jail as well, they told him or not, has a detainer that's been placed upon him by the U.S. Attorney's Office, federal court in West Virginia. So I don't know, at this point, he's not been released from the holder from this case. I don't know if the state's intent is to convert this to an OO bond or the state wants to continue to hold him at this point. I don't know what they want to do.
Well, I haven't seen that detainer, but
May I approach?
You may. And Mr. Eplin, have you seen it? Have you seen the detainer that has come through from out of the Southern District of West Virginia?
Yeah.
Okay. Well, they filed a detainer on you today out of the Southern District of West Virginia, and requesting that you be sent back there for whatever the issue is that you have there. But I just wanted to make you aware of that came through today. Your attorney has it.
Oh, that's
He's
right.
it, and he's speaking with the prosecutor about that.
let's have him sentenced.
We can't go. Well, can he go when the law's over sentence?
Yeah.
Okay. Well, Your Honor, actually, I'm reminded that he pled guilty to the charges, to everything that's pending on, was it Monday or Friday of last week?
That was,
It was on Monday. And we set him here today because we were not, so our bond isn't the issue. We were going to, part of the sentence was going to be that he go to treatment on an ankle monitor. So, at this point, I don't know if we sentence, I guess he wasn't technically sentenced, but the anticipated sentence was that. So if we sentence him now, I think West Virginia would be, West Virginia, the federal government would be free to come get him.
Mr. Gill?
I think that that's the most expedient way to deal with this, Your Honor. He pled guilty to a misdemeanor theft charge. He also, let's see, what was the OVI? It's a third offense. What we would, I think it's most expedient then at this point, since really we're not going to be able to send him to treatment. If he were to be sentenced today to a sentence that would be commensurate with the mandatory minimums on the OVI charge, but which are conditioned that if the federal government authorities came to pick him up, that he could be released today. We'd be satisfied with that.
Okay. And on the theft charge?
Have that concurrent.
And the OVI in this case is from December of last year, so I believe it falls under the prior statute.
Okay. All right. Mr. Eplin, well, that kind of changed things from where you were the last time you were here. But what your attorney has represented to the court in the state of Ohio is to go ahead and sentence you here, and we are willing to run anything here concurrently with anything that you would get through your federal charges in the Southern District of West Virginia so that they can come get you and we can get that behind you as well. So,
And he has 16 days of jail time credit.
okay. So what I'll do then on the OVI, we'll start with the PRC 24-2509 case. We'll do 30 days jail. He'll get credit for 16. Credit for 16. There will be a $850 fine. Out of the court costs. I'm not going to order any community service because he's going to complete the case by jail time. And that case is going to run concurrently with CRB 25307 and 25307. And any time that he would have based upon his federal charge. And he can be released to the federal government when they want to come get him. Assuming they do that before the end of his sentence. On the, there won't be any probation on this because his sentence is going to be completed by jail time. And then on the CRB 25307, Mr. Steyer, was there a driving under suspension on this, or was that just the?
Let me take a look at the ticket, Your Honor.
Oh, there is, okay, I missed it the first time. And it'd be a $50 fine there. Or actually, no, let's just. Mr. Hill, the B case on the OVI, it's a driving under suspension, and given that this case would be completed by jail time, do you want to keep that? The B case?
Would you like to nollie that, Phil?
Oh, I don't care to nollie.
Okay, we'll nollie the B case. Was there any restitution on the theft charge?
No, Your Honor.
Okay. On the CRB 25307 case, I will sentence Mr. Epplin 16 days in jail, give him credit for his 16 days, and that case will be terminated.
Thank you, Your Honor. He has old cases pending that were on the review docket as well, I believe. I would ask, I don't know what the court wants to do with those.
On the review matters, I'm going to leave those and we'll set them out for December. We'll set them for December 12th for review
And return to the review docket.
and return to the review docket.
Thank you.
Is December 12th was the date we used for your other case earlier? wasn't it?
Apologies.
Was December 12th the date we used for your other case earlier?
I think you might have said the 8th or the 12th. I wrote it down and then kind of forgot because it wasn't on the review docket. I don't handle them at that point.
The 8th. We'll do December the 8th. All right, so, Mr. Eplin, if you, once your stuff is completed in West Virginia, you'll still need to come back here for review. If you're out before then, it'll be December 8th, 2025 at 9 a.m. for review.
Okay, so I'm free for the federal government to come get me now?
Correct.
Yes, they can come get you now. And is there somebody listening from the jail that heard that and can make them aware?
They said that they need somebody from the jail to make it aware that I can be released to the federal government now.
Yes, Your Honor.
He can now be released to the federal government.
Okay. Thank you.
All right,
Thank you.
Thank you, Your Honor.
Thank you.
State of Ohio versus Charles L. Moore, case number TRD 25433, and Joshua Morrell is on deck. Merle or Morrell?
Mr. Moore, can you hear me?
Yes, sir.
All right, this is State of Ohio versus Charles Moore, TRD 25433. Mr. Moore, it was alleged that you had failed to appear back on March 14th, 2025 on a driving under suspension. At that point, there was a warrant issued, habeas issued for you. So what I'm going to go ahead and do is I'm going to go ahead and arraign you on this. And you can enter pleas of either guilty, not guilty, or no contest. Guilty means you're admitting the violation. Not guilty means you're denying the violation. And no contest means you're not admitting the violation, but you're not contesting it either. Do you feel like you understand my explanation?
Yes, sir.
All right. Mr. Moore, it's alleged on or about March 11th, 2025 in Fayette Township that you were operating a motor vehicle on a suspended license. It's a violation of Ohio Revised Code 4510.11a. It's an unclassified misdemeanor. Maximum penalty on that is up to a $1,000 fine and up to 500 hours of community service. How do you wish to plead?
No contest.
All right, I'll accept your no contest plea, and I'm going to enter a guilty finding on that. Now, do you admit or deny that you failed to appear for your arraignment?
I admit, like, the March 11th is the day my wife passed away, sir, so it was a very difficult time.
All right, well, I'm sorry to hear that. How many days have you spent in jail?
I got here Tuesday.
All right, so what I'll do then on the failure to appeal, I'll sentence you to 3 days jail, give you credit for the 3 days you've served. And on the driving under suspension, it'll be a $50 fine and court costs.
Does that have to be all paid at once, or can I pay that over a couple of months?
We typically set them, we're going to set you a review date, and if you have it paid off by the review date, you don't have to appear for it. If you don't, then you have to appear. If you don't appear for your review, then you'll get another warrant.
I'll have it paid off by then.
Okay. So I will set you a review date. I think we're going to be doing those on Tuesdays now. For August 26th. At 9 a.m. If you have it paid, if it's all taken care of, you do not need to appear for that.
Thank you, Your Honor.
Thank you.
State of Ohio versus Joshua Morrell, case number CRD 17169, and Michael White is on deck.
Mr. Morrell, can you hear me? Mr. Morrell, can you hear me?
My name is Michael White.
Can you respond?
State of Ohio versus Michael C. White, case number CRB 19452.
All right. The State of Ohio versus Michael White, CRB 19452. Mr. White, it's alleged that on July 15th, 2024, you failed to appear for a review hearing and there was a bench warrant issued for you. Do you admit or deny that you failed to appear for your review hearing?
Yes, sir. I've been incarcerated in CCI prison.
Okay. When was that?
I got locked up, I turned myself in May the 29th of 2020.
All right. Well, not a good reason, but a legally sufficient reason, Commissioner here. So what I'm going to do is I'm going to recall the warrant.
My outdate's 2027.
Okay. So so how did, out of curiosity, how did you wind up back here if you're still?
I got something to come up again, for me across the street to big court.
Okay, so you got something else there?
Yes, sir.
All right, so you're not going anywhere then until 2027 is what you're telling me?
Yeah, June the 23rd or 27th is when I'll be.
All right, well, what I'm going to then go ahead and do is I'm going to go ahead and just sentence you to complete your case by jail time.
Good.
And that way your case here will be closed out. So what I'm going to do is find that you failed to appear on that. I'm going to sentence you to 13 days. I'm going to give you 13 days credit and your case will be completed by jail time.
All right, thank you, sir.
Thank you.
Your Honor, is that 1950?
Yes. We'll see who comes up next. You're finished, sir. Sir, can you hear me?
Yes, sir.
What's your name, sir?
Joshua Merle.
All right, this is State of Ohio versus Joshua Merle 7, case number CRB 17169. Mr. Merle, it's alleged that on or about, it looks like July 5th, 2024, that you failed to appear for a review hearing. Do you admit or deny that you failed to appear?
I can't hear you.
So On or about July the 5th, 2024, it's alleged that you failed to appear for your review hearing on one of the cases.
Yeah, I was in Central Living, and they didn't give me my court date, so I didn't know what it was.
Okay.
Well, and when I went there, because I went there on my own, I left on my own.
All right. So you were in treatment at that time?
Yes, sir.
All right. What I would like to do for you before I do anything on this, I want to have you, how long have you been in jail?
1 day, since last night.
All right. I would like to have him screened before we...
I'm not on probation or nothing, why am I getting screened?
Well, you have an active case here, from where you failed to appear for your old case on review where you're on probation.
I'm not on probation.
Well, I'm looking at it here, sir, so you can...
Yeah, they said I'm not on probation, sir. They got that wrong.
Well, I'm having you screen
Man, this is crazy.
All right, well, you're going to get called later on in the docket, and we'll see where we go from there. So if you want to act out, you might end up staying there longer. We'll call that later in the docket.
State of Ohio versus James DeMint. Case number CRA 24-290, CRB 24-635, CRA 24-786, CRB 24-787 A and B, TRD 23-1859 A and B.
All right, this is State of Ohio versus James DeMint, CRA 24-290, CRB 24-635, CRA 24-786, CRB 24-787 A and B, PRB 23-1859 A and B. Mr. DeMint, can you hear me?
Yes, sir.
All right. This is, looks like Mr. Smith, right, or Mr. Tylerson's case.
Yes. Your Honor, it'll probably give you a little background.
Looks like there's some history here.
There's history. Mr. DeMint pled to everything. It's still in the pretrial docket. I believe there was one issue. I don't think we ever addressed it, but it was one of them was about restitution. I don't believe there was any restitution. So he was sentenced to consecutive 6-month sentences in jail. However, there's going to be a review after 30 days. He's now spent 30 days in jail, and with the possibility of going back to treatment. And I believe, he was at. Were you at RRS? Where were you?
Yes, sir. RRS. I'm still at Roll area.
Okay, they were willing to take him back, but it was going to be on inpatient because when he did go in, he did test positive. So we're at the point now whether he's going to be released and suspended the rest of the time so he can go back into treatment.
That is what we had discussed back on May the 9th. We reduced some charges and he pled to a number of charges, and the court gave him a total of a year of incarceration, and we talked about him going back to treatment after about 30 days, so it's almost 30 days. We also were going to seek information about restitution. Okay, so the victim is not asking for restitution, so restitution is not an issue, and if the court feels it's time for him to go back to treatment, and if there's a provider that wants him, we're okay with that.
All right. If the representative from RRS is here, if they could just step in the courtroom, please.
He's doing an assessment.
Okay. I'd like to hear from them. All right, Mr. McKeon, this is, we're here on James DeMint. Are you guys wanting him back?
At one time we was, now I don't think that we would be able to take him back.
Okay.
Yeah, at this time, we won't be able to take him.
All right. Would there be any other providers? All right, Jesse, if you want to assess Mr. DeMint, we can recall this here in a bit. You want to assess him for treatment, and then we can make a decision on whether he's going to be judicially released as today.
That's fine, Your Honor. Thank you.
All right. Mr. DeMint, you're going to get a call here shortly for an assessment from Hometown Recovery. And then we're going to recall the case here shortly. Thank you.
Thank you.
State of Ohio versus Kelly Doss, case number CRA 25206, CRB 25207, A and B.
Mr. Doss, can you hear me? Mr. Doss, can you hear me? He's muted. Still muted. All right. Mr. Doss, can you hear me?
Yeah, can you hear me?
I can now.
Okay.
This is State of Ohio versus Kelly Doss, CRA 25206, CRB 25207, A and B. This is Mr. Steyer's case.
Your Honor, Mr. Doss is awaiting an ankle monitor so that he can be released to RRS. They have a bed for him. We're just looking for a monitor. It being Friday, I'm not optimistic that it would happen today, although that's not out of the question. We probably need to set this back again to be able to follow up. I think Monday would probably be, there's nothing to stop him from getting out once the monitor's there, so we don't necessarily need to come back Monday.
Okay, so the bond was already been, that isn't the bond.
Right, we're just waiting for the monitor. So we can come back Monday if the court if the court wants to, we come back Friday or the following Monday. I'm gonna be gone after the 16th until the,
Let's,
27th. The 20th and the 23rd, I'm unavailable.
let's put it on the 16th. So at the defendant's request, this matter is going to be continued to June 16th for a preliminary hearing.
out, bring him on the 16th. That works, I got you. Appreciate it.
All right, Mr. Doss, could you hear what your attorney at stake indicated to the court?
What is it now?
Could you hear what your attorney indicated to the court?
Yeah, waiting on the monitor.
Just waiting on a monitor. I've set you back for a preliminary hearing June 16th at 10 a.m. So if you are released to treatment on that monitor, they'll need to bring you back at that time. If you are not released, then we'll see you back at that time.
Okay. Well, that should be before then, right?
We would expect so.
We would expect so.
We would expect so.
All right, thank you.
Yep.
Your Honor, we have several recalls to the jail, but we're not ready for any of those yet, so we can proceed here in court. State of Ohio versus KCN Great, case number CRA 2591, CRB 2592, A and B. This is set for trial, Your Honor.
So State of Ohio versus KCN Great, CRB 2592 A and B, CRA 2591. Ms. Great's present with her attorney, Mr. Peaches, and the state's represented by Attorney Fulton.
Your Honor, she appears on 2 cases, a felony and some misdemeanors. I had a chance to speak to Mr. Heald this morning. We're still discussing the case. On defendant's motion, I would ask the court to reset both of the cases. I would propose Monday, July 21. Or Friday, July 25, if that...
Either of those, if you've got a preference.
Monday would be my preference, Your Honor, the 21st.
At defendant's request, this matter will be continued to July 21st for preliminary hearing and pretrial at 10 a.m.
Thank you.
Thank you, Mr. Davis.
State of Ohio versus Justin Marshall, case number TRC 25771.
The State of Ohio versus Justin Marshall, TRC 25771. Mr. Marshall is present, his attorney, Mr. Eaches, state's represented by Attorney Phil Heald.
Your Honor, I filed a motion to suppress and a motion to compel. I never have discovery issues in Mr. Heald's office, and I'm not having issues in this case. I was up against the deadline, and I didn't think I had time to make an informal request. I believe Mr. Heald's reviewed the video and agrees that information is important. I agreed to extend the deadline to provide that. 14 days is fine. I would ask to come back to pretrial, both the suppression motion and hopefully the motion to compel will be moot at that point. I would look at Friday, June 20, Your Honor. That's a deviation from the date that Mr. Heald and I had discussed. I would prefer Friday, June 20, Your Honor.
At defendant's request, and I'd already signed off on the agreed entry on the motion. Defendant's request, matter will be continued to June 20th, 2025 at 10 a.m. for pretrial.
Thank you.
Thank you, Mr. Eaches.
State of Ohio versus Adam Hudson, case number TRC 25978, A and B. This is Mr. Roger Smith's case.
Well, there's a motion.
This is State of Ohio versus Adam Hudson, PRC 25978, A and B. Mr. Hudson is present with his attorney, Mr. Roger Smith, state represented by Attorney Phil Heald. Matter set for pretrial.
Judge, we have received discovery. In fact, Mr. Hudson was in the office yesterday. I think this is going to be resolved. I would like one more pretrial. We didn't waive time because we literally did just have a chance to look at the discovery.
All right, is there a date you're looking at?
Judge, I am here June 27, July 7, or July 11.
Let's go to June, at defendant's request, let's go to June 27th.
Okay.
For a pretrial at 10 a.m. And I'll find that time has been waived for this matter.
Yeah, we will sign the time waiver, Judge. Yes, sir.
State of Ohio versus Buddy E. Malone Jr., case number CRB 24820, A and B.
This is State of Ohio versus Buddy E. Malone Jr., case number CRB 24820, A and B. Mr. Malone is present here with his attorney, Mr. Roger Smith, state represented by Attorney Phil Heald.
We'll find out. I know that I think I
saw the last case. And also the date it moved. I forgot.
Oh, that's mine. Do you have an extra? I gave it to you. It's Phillips. Do you have an extra? Oh, no.
Oh. I'm going to give you my phone next.
Okay.
Well, what I'm saying, that's what we're here for. I mean, in other words, we
Yeah.
didn't know if there was anything still pending.
Oh, okay, yeah. 'Cause he's already in treatment on the other. Chance, we can contact the alleged victim.
Yeah,
She wants to dismiss it?
yeah.
Okay.
The only thing we need to do then is sentence on the
Dismiss.
identity for the theft. Your Honor, if you please report, there are a couple of 2024 cases that are still pending. That was a domestic violence and unauthorized use. Those have never been resolved. However, some time ago, we spoke with the alleged victim, and she didn't wish to have the cases pursued, and that was about a year ago at this point. The other cases, there were a couple felony cases that went to the grand jury, and apparently nothing has taken, there's been no action on those according to the docket. So we don't know what's going on there. However, he previously pled guilty to a theft charge, and that was a Walmart case. So I think that's, we intend to dismiss those 24 cases, and we'd ask that he be sentenced on the theft charge. And
I only have the CRB 24-820 A and B, and the A is the domestic violence and the B is the unauthorized use.
this is the only case that he had. All right, well, he's also got,
I think he may have already been sentenced. He was here for review.
He's on the review docket. He was
Yeah, he was
here
here for review this morning.
I think those are already taken care of.
okay, well, then there is, we're going to go ahead and move to dismiss the 24 cases.
Okay.
Okay.
CRB 24-820 A and B will be acknowledged at state request.
Thank you, Judge. Thank you, Mr. Prosecutor.
Thank you, Your Honor.
You're good. I guess we'll see you next review. You already got the date on that. All right. See you.
State of Ohio versus Trenton R. Moore, case number CRB 25-2.
All right, this is case number CRB 25-2, State of Ohio versus Trenton Moore. Mr. Moore is present, his attorney, Mr. Roger Smith, state's represented by attorney for appeals. Prior to delving deeply into this, I would indicate that for the record that in the event that there is not an agreed upon resolution today or something agreed upon, I would have a conflict to hear this. However, I believe that I could hear this if in the event that there is nothing that is contested. And so for the record, I will state that and then I'll turn it over to Clark.
Sure, Judge, it's my understanding in looking at my notes that the case was ultimately dismissed upon payment of court costs. How much are court costs, he asked, because he could probably pay that today.
Court costs are $125 unless there's an insurance or sheriff's fees, something like
Warrants,
that.
did you? 125? No warrants. Didn't have to arrest you. No warrants, so 125?
I'll have to leave.
Before 4 o'clock, okay.
Has he completed the program?
He has not.
Oh, well, that could be an issue if he's
We
not.
want him to finish it. And we're encouraged, apparently he's doing very well in all respects. And, but the report indicates that they're encouraging regular attendance and helping him stay on track with his goals. So we want to see him complete that program.
I misread, the bottom says date of completion 6/6. I thought he graduated. That's why I thought we were ready. understand, that means the report was completed today. Not, okay, so that's, yeah, I understand, that's not an issue, he wants to complete the program. I might have been premature in my interpretation of what that letter says there.
So we'd ask for a continuance to let him finish. We're encouraged that he's doing well.
The 30 days.
Stewart says he's doing well, so.
It's above my pay grade, so.
Still filling drug screen. You can do it.
There's some logistical things. They're going to work that out. He understands he's got to complete them. I suggest 30 days out, at July 7th date maybe, or if we have to come back sooner. 30 days out sounds right.
All right, at defendant's request, this matter will be continued to July 7th for pretrial. Thank you.
Thank you.
Thank you.
State of Ohio versus Alexis J. Neese, case number TRD 22766, TRD 211431, TRD 183892, TRC 183326, TRC 191170, A, B, and C.
To the dismissed phone call, switch that.
All right, this is State of Ohio versus Alexis J. Neese, Peter 766, TRD 21143, TRD 183892, TRC 1827, TRC 191170, A, B, and C. Looks like this is Mr. Rogers Smith's case.
It is, Your Honor, and she is in treatment. What do you treat with?
The counseling center.
Kansas.
My understanding is the counseling center is not here today.
Aha. Well, she indicates she's going to get a good report. I just haven't seen her. And she, I know, last year reports have been good.
Yeah.
There was a hiccup in the beginning. We're well past that. She's on board doing what she's supposed to my knowledge.
All right, well, to your credit, Ms. Neese, you're here today, and you look like you're in good spirits, and you look healthy.
Thank you.
Which is a good thing, and so, Mr. Smith, how far out? We're going to the 7th as well.
I'm here, Judge, without even looking at the 7th, to be fine.
All right, we're going to set this back for July 7th, 2025, back as a pretrial.
Thank you, Your Honor.
Thank you.
Here's the finish line.
Yeah, thank you.
State of Ohio versus John C. Henry, case number TRD 25139. Mr. Stratton's case.
Your Honor, Mr. Henry is in jail in West Virginia, so.
Okay. Mr. Hill? This is State of Ohio versus John C. Henry, CRD 25139. Mr. Stratton's case. Mr. Stratton has just indicated that Mr. Henry is incarcerated in the lovely state of West Virginia.
Well, that being the case, we would ask that a warrant issue for him so that we can get him back in here after he's released from West Virginia.
All right. We'll put a note that he is incarcerated in West Virginia, and based upon that, there'll be a bench warrant issue, and we'll see him back whenever he turns up. Thank you, Mr. Stratton.
State of Ohio versus Brittany Kazee, case number CRB 24489.
Your Honor, this case has been set for Ms. Kazee to pay restitution. She called this morning, had a car trouble, actually a busted rim and some issues. I think we can just reset this if the prosecution is okay with that.
Mr. Hill?
Trying to figure out how to spell Kazee.
not kazoo.
There's a number of different ways that it's spelled. Is it K-A, what is it?
K-A-Z-E-E,
Z.
not K-A-Z-O-O. Any issue with the continuance in this matter?
Well, I suppose not. We're trying to get restitution from her, I suppose, so.
She has paid some.
Okay. Let's continue this to July 7th. Are you available, Mr. Stratton?
That's a bad day, Your Honor.
How about July 14th?
Yeah, that'll work.
All right. July 14th for a pre-trial. I had car trouble myself yesterday, so I sympathize today.
State of Ohio versus Sid Mosser, case number CRB 24-258, TRC 24-487.
All right, this is State of Ohio versus Sid Bosser, CRB 24-258, TRC 24-481. This is Mr. Stratton's case. Here's Mr. Bosser here.
Yeah, he is a, he does no more.
He's not?
OVP.
When did he leave?
Yeah, he's not this long.
Back in early May, maybe? Yeah, on 4/28, he was with you.
Yeah, in April.
In April, left shortly after that?
The RRS and was only there for maybe
2 days.
a couple of days and then took off.
So, there's that.
All right, there'll be a bench warrant to issue immediately for failure to appeal. Come on, sir. Skipped out on his treatment and that's not here.
State of Ohio versus Jordan Wiley, case number CRB 24-565.
Your Honor, she's appearing by video.
Oh, sorry.
All right, this is State of Ohio versus Jordan Wiley, CRB 24-565. Ms. Wiley is on Zoom, and this is Mr. Stratton's case. But before we begin here today, I presently represent Ms. Wiley in the case, and so I don't believe that I can hear this.
Well, and that's why I knew that, I was going to bring that up. We'll just reset this to another date.
Any issue with that, Mr. Healy?
We're not opposed to that, Your Honor. In fact, if she were to be able to give us a good report today, we wouldn't have a problem with waiving that conflict if the court.
Otherwise, we continue. Judge in that position, so I think we should just reset it.
Well, can I just say this, my psychologist that typically writes in the reports, he is transferring from Oasis to Valley Health these next few weeks, so it's going to be like hard to get in with him and make sure that he'll be able to produce the report that you guys are asking for, so it's probably better if we do extend that.
So what are you thinking, maybe towards the end of August, end of July?
Yeah, that way it'll get me time to get acclimated within Valley Health and get on the schedule as much as I would like to be, and that way he can run in as sufficient support.
All right, how about July 28th?
That'll work.
Okay, so.
All right, July 28th, 10 a.m. for pre-trial.
I'm sorry, can you say that one more time?
July 28th, 10 a.m. for pre-trial.
Okay, am I going to be appearing in person?
It's up to the judge, but I don't think it's necessary as long as we have a report.
Okay, all right, I'll make sure that I take care of that on my end, and Sean, I'll talk to you soon, and then thank you, Your Honor.
All right, thanks.
All right, thanks.
State of Ohio versus Brittany Eflin, case number CRB 23-589 A and B. That's Mr. Morford's case.
This is State of Ohio versus Brittany Eflin, CRB 23-589 A&B. Ms. Eflin is present with her attorney, Mr. Morford, who's entering the courtroom now. The state's represented by Attorney Phil Peel. Set as pre-trial.
Morning, Your Honor.
Mr. Morford.
She has been in counseling, Judge. She's at TCC presently. I don't know if you've gotten a report yet
I've got one from 521, and PCC is not here today, as my understanding. But, Ms. Upton, you're here, you look healthy, and you look like you're doing pretty well. You feel good?
Yes.
Judge, she has asked me to move the court for a change of providers. She would like to be closer to home and be able to seek employment. And if you would you explain to her that making an oral motion is the same as filing a written motion?
We'll read through the prior report real quick, or maybe...
You're all right. I have an updated report.
Okay, thank you. Have counsel approach. I'll give you an opportunity to review the report. See first, Mr. Milford. You guys want to read it? Yeah. Looks like it. She's not. She's not. I think taking the program seriously, she needs to. suspended. I'll let you make your motion, Mr. All right, we're back on record. I was provided a report from Nikki Thompson, CDCA, at the Counseling Center. Pre-trial bench conference, Mr. Morford has indicated that he has a motion to make on behalf of his client, and Ms. Eplin, a oral motion and a written motion as far as the court's concerned are the same thing. So Mr. Morford can make that motion today on your behalf, and I'll go ahead and hear it. He'll make the motion. Mr. Hield can argue either for or against it, and at the end of the day, I'll make a decision on it. Do you feel like you understand that explanation?
What is going on?
You asked me to ask the court.
I knew that, but you said my report's not good. I've been doing great.
Got a report here, and I don't know that I would say that you're not compliant, but I don't know that you're
I've been compliant with everything.
Now, hang on, let me speak.
Don't interrupt.
So, I don't see any instances of non-compliance, but I don't know that you're fully taking it as seriously as what you probably should.
That I am.
But again, I'm willing to hear a motion.
Yes, sir.
If you want the motion heard. If you don't, Mr.
Yes, sir.
Morford doesn't have to make it, but if you want the motion heard, I'll hear it today.
Okay.
All right, Mr. Morford?
Thank you, Your Honor. If it please the court, counsel, Ms. Eplin has been in touch with me a couple of times, most recently as this week, and requested that I ask the court for permission to change providers to a provider of care that is closer to her home, and it would also have the benefit of allowing her to seek employment. I believe those are her two main reasons for asking for a change from TCC to, did you have someplace in mind you wanted to ask the court to go to?
Lawrence County Recovery or Brighter Days, one of the two.
Sorry, I heard the first one, I didn't hear the second one.
Brighter Days.
Okay.
Or Lawrence County Recovery,
Or LCR.
or anywhere at this point, closer to home.
Anything further on that, Mr. Morford?
No, thank you, Your Honor.
All right, Mr. Gill?
Your Honor, if it please the court, I guess it gives me some concern that on the one hand, I believe that Ms. Eplin feels like she is doing what's being asked of her. But the counselors feel like there are certain aspects of the counseling that they're trying to provide to her that maybe she's not really fully willing to engage in, if that's the correct reading, and that there are certain areas that she's not progressing in. And apparently she doesn't, I don't know where the disconnect is. And under normal circumstances, if, of course, we don't have the advantage of having a representative from TCC here today, and that would be helpful. If a person is compliant and they are at a stage in which it is obvious that a change would be beneficial, then we generally want to go along with whatever the counselors say and whatever provides the best path to completion of the treatment. But I'm not sure that we're at that point here. And if there's an attitude issue with Ms. Eplin where she needs to become maybe a little bit more humble and needs to really listen to what's being asked of her and break down some barriers and start trying to, really get at some issues that maybe you don't want to talk about. Maybe that's the problem, I don't know. But, there's always the prospect of 6 months in jail, which we'd rather not have to do. We'd rather not have to ask the court to do that, but that's always a threat. So I guess what we would like to see is not to discount her request, but maybe grant that in the future based on whatever compliance, maybe her compliance is a little bit more complete between now and the next time we come back to court. Maybe be a little bit more honest with herself and do more of what they're asking of her. And I don't know whether she's had a chance to even read what's being said.
No, I have not.
That might be beneficial too.
Because I'm confused. I've been doing everything that I'm supposed to be doing.
Maybe if the court maybe would read some things to her.
Well, I don't want to read
I
this
have
into
been
the
compliant
record,
with
but I would be
everything.
happy to allow Mr. Morford to be able to make a copy of it for his file and to be able to show his client as well, because I believe she'd be entitled to that.
And we wouldn't be opposed if we came back in a relatively short time frame so that we could discuss this further.
I mean, I've been paying clean, I've been going to all my groups, everything I'm supposed to do, all my appointments, I attend all my meetings. I mean, I don't understand what exactly am I doing wrong.
Okay.
May I ask that?
Well, you're going to get an opportunity to review this with your attorney. So, and I want to speak directly to you, Ms. Upland, about this a little bit. So, again, there's nothing in this report that indicates that you are non-compliant.
Right.
So let's start there. I'm not looking right now at, going, oh, we're going to revoke your bond and put you in jail. We're nowhere near anything like that.
I don't want to do that.
So I'm not even saying that this is a terrible report. I think they are more expressing there's still some issues that you're working on and that you need to work through. I don't, without having a counselor here or representative from PCC, I don't know that I have enough information to be able to say, because I'll give you a good example. One of the things in there is that, and Mr. Morford has referenced, is that you're looking, that you would like to gain employment. You
I'd
went
also
from
like to
2.
go back to school and be closer to my family.
Sure, you went from 2.5 to the 2.1 level of care, and you've been in there for 30 days. At this point,
I've been in treatment for like 6 months, been clean for 6 months now.
without having a counselor here today, I don't know whether even there you would be eligible for it or what. So here's what I'm more inclined to do. I'm more inclined to go with what the state has requested at this point. I'm not going to outright deny your motion. I'm just going to find it not well taken at this time. If you have another good report, and we'll come back fairly quickly, if you have another good report, the state's indicated that they may be, willing to be on board with that. And if they're on board with it, I would believe that there's probably a fair chance Judge Capper would also be on board with it as well. But the primary thing is, we need you to really get in and work through the issues and get into the program and do it. I'm not saying that the way I read this, and maybe I'm wrong because I don't have the counselor here to be able to say. I know that they're saying that there are some issues that you're working through, but the way I kind of read it is you may be doing the minimum rather than the maximum there. And so want to see you be successful, primarily more than anything else. We want you to be successful. We want you to be able to get employment. We want you to be able to go to school. We want you to better yourself. That's good for everybody. But in order for you to be successful in those things, you've got to work through all of these issues and get to where you're at peace and where you need to be before you can be successful the way that you want to be and the way that we want you to be. So we're going to come back. Mr. Morford, are you available July the 7th?
I believe so, Judge. Give me 1 second. Yes, Your Honor, I'm here.
All right, we'll come back in 1 month, July 7th, for pre-trial at 10 a.m.
Hang on a minute there. I'll get you a copy of the report. Thank you, Your Honor.
Thank you.
Your Honor, we'd like to have a copy of that too for our file.
Sure.
I'll make one.
Mr. Morford, if you want to approach, I'll go ahead and give you the file.
Thank you.
Thank you, Mr. Morford.
State of Ohio versus Jacqueline Chin, case number CRP 25317, TRD 151164, TRD 15971.
Permission to approach.
Okay. This is State of Ohio versus Jacqueline Chin, CRB 25317, TRD 151161. 64, and Kearney 15971. This is Mr. Morphin's case, set as a pretrial.
Sorry, Judge, my head was
You're all right. It's probably froze. It's so cold in here, it's probably froze.
It is a little chilly.
All right. Ms. Chen, it's a good report.
Yeah.
Judge, we'd like to maintain the status quo. I haven't seen the report, but she says she's doing well.
It's a good report.
Good.
All right.
Thank you.
Let's come back July 7th at defendant's request for pretrial, 10 a.m.
What's the date, Your Honor? I'm sorry.
July 7th.
Thank you.
Thank you.
State of Ohio versus Tiara Smith, case number CRB 25312.
All right, this is State of Ohio versus Tiara Smith, CRB 25312. Ms. Smith is present for her attorney, Mr. Morford. State's represented by Attorney Phil Heald. Matter set as pretrial.
Your Honor, if it please the court, I had not yet been able to discuss in great detail this case with Mr. Morford. However, what we would be willing to do with Ms. Smith at this time is if she were to plead guilty, we would offer a suspended jail sentence of 30 days, and we would want her to complete parenting classes.
Mr. Morford, did you hear the offer made by the state?
Yes, Judge. My client is declined that offer.
Okay. How do you want to proceed from here?
Could we have another pretrial judge? Don't really need anything far out, but I'd like to have opportunity to have her come in
All right.
and discuss our defense.
All right, defendant's request, it'll be July 7th at 10 a.m. Since I already know you're here, Mr. Morford.
We would waive time too, Your Honor.
All right. I'll find that time in this matter has been waived by the defendant.
Thank you, Your Honor.
Thank you, Mr. Morford.
State of Ohio versus Shane Sowards, case number CRB 25186, CRB 25255.
This is State of Ohio versus Shane Sowards, CRB 25186, CRB 25255. Sowards is present with his attorney, Mr. Morford, and the state represented by himself. Matter set as pretrial.
Yes. Here's what I'm willing to do. If you're going together with him now, I think that there needs to be no guns in the house. You gotta find some place to put the guns. Mental health issues and parenting classes for both of you. I think that we need to make sure that there are no mental health issues that need to be dealt with. And you both should take parenting classes. Yes, it can be arranged. That's fine. And there are agencies out here that can provide those services. I'm sure they've got evening time or whatever. Now, I'm not guaranteeing that I'm going to recommend that this be dismissed in the future. But I think that you all need to do that stuff in order for me to convince me that I should dismiss the charges. Okay? Is that okay with you? Is it your guy? All right, well, Your Honor, the court's ready to proceed. Your budget.
Okay.
This is a very serious situation involving allegations of guns and domestic violence. So our alleged victim is Bailey Sowards, and she's here.
Haley.
Haley. Oh, yes, that's my eyesight failing me. We would be making no guarantees that we would be willing to dismiss the charges at a later date, but in order to put themselves in a position where we might consider it, we would be requiring and requesting that some things are done. First of all, I believe that there needs to be some proof that there are no mental health issues, or that any mental health issues that there are being addressed. So we've asked that take place. I believe that both of them should take parenting classes. And also, if there's any guns in the house at this time, that they should be removed. And then come back at a later date, check their progress, and maybe, of course, that's going to be up to the court as well, because I know the last time we were here, I think Mr. Judge Capper had some concerns based on the allegations. So this is just a step. If they're willing to do that, then I think that it might lead to a better resolution. Yeah, and because Mr. Sowards' works indicated that they'd have to arrange some parenting classes after work hours. But we would want to see them do those things.
Mr. Morford?
We're on board with that, Judge.
All right. How far out do you want to go?
Maybe a month to allow them to at least get a session or two in.
I'd like also to know what who's going to be doing, so maybe if they could talk to the counselors here and see if there's who could provide those.
Have you talked to anybody about that?
She's told us to me about counseling.
About what?
About whole counseling. That's the,
I've been depressed, so I went to a mental health place so I can focus on myself. And I go to Shawnee.
Shawnee, I think is the place it's called.
Well, I believe that she has a provider in mind for providers.
As long as the provider is one that will provide the court with updates on the progress and everything, that would be, because some providers in that.
I don't know if Shawnee does it or not.
They're not very.
You guys find someone.
So it might be a better idea if the counseling would take place at one of the agencies that we know that will provide us with updates.
I'm not gonna get involved with who does the counseling, with the medical decisions. I mean, that's, you know, the state is free to withdraw that offer if they don't want to go to where you want or the like, or if we're not getting updates, then we can address it at that point. But there's not been any guarantees of anything made. This is kind of a preliminary step, and so I'm inclined to go along with the continuance about 30 days to determine, you know, what progress has been made, if any, at that point, and then we can take any problems that may arise or may not arise up at that time if we need to. So I'm going to set this back July 7th, fitness request at 10 a.m.
I guess I'd like to know if any of the providers here would be willing to talk to that. That would be.
Looks like Mr. McCann back there would be happy to speak with them.
Talk to Mr. McCann. Okay. So, July the 7th, Your Honor?
July 7th, 10 a.m., pre-trial.
State of Ohio versus Calvin T. Thomas, case number CRB 25.
What about another case? What about another case?
It's all together.
Right, this is State of Ohio versus Calvin T. Thomas, CRB 25-276. Mr. Thomas is charged with his attorney, Mr. Morford. State's represented by Attorney Philip. Matter set for pre-trial.
Which we didn't have.
The video. Have any questions?
Anger management and 90-day continuance, dismissed with costs if he's successful and no further problems.
You would agree to go to anger management?
Yeah, I do.
Yeah. Judge, I believe that we've reached an agreement that my client would attend anger management counseling and come back after that's over, at least 90 days out, and the state would consider dismissal of the charges at that time.
Was that with or without cost, Mr. Gill?
We would ask for costs.
Mr. Morford, how does September the 8th sound?
Perfect.
Now we continue the defendant's request to December the 8th, 10 a.m. for pre-trial.
See you then.
You have to probably get with a provider too.
Y'all know a good one to go to.
Anger management counseling. There's providers here in the back of the room.
State of Ohio versus Jordan D. Wolf, case number CRB 25-123.
What was the date of the next hearing on that last case?
9/8.
September 8th. The State of Ohio versus Jordan D. Wolf, CRB 25-123. Wolf's present, her attorney, Mr. Morford. State's represented by Attorney Philip. Matter set for pre-trial.
You still insistent on pleading?
Yeah, I'm not.
Not pleading. No, man, I'm set for trial then. You want to talk about your rear about it?
It doesn't matter.
I know Judge
I
Kane.
text me, see if I have other sheets.
Judge, we're not going to be able to resolve this short of a trial, bench trial.
Okay. Mr. Hill?
Well, and that's fine, Your Honor. I made mention when the last hearing date, when Ms. Wolf did not appear, that for the trial, that we have in this case a particularly strong case because not only do we have surveillance video from the store that actually shows her activities and shows her leaving without paying and acting very suspiciously in the process, but there was a deputy there to receive her on the way out of the store, and so therefore we get a view into what happened in that office where they took her upon apprehending her, and the evidence against her is overwhelming. So if we have a trial and if the state wins, we're going to ask for her to go to jail because we think that this is such an obvious case that I think the lack of her coming clean and accepting responsibility, I think, is exceptional in this case. So just wanted her to know that.
Okay. Mr. Morford, how far out would you like to go on that?
Maybe into July, later July.
How about July 21st?
That's good to hear, Your Honor.
All right. Mr. Hill, does that work for you?
July 21st, yes, Your Honor.
All right. So we'll set this for a bench trial, July 21st at noon.
Do you want to hear that from missing on the other sheet?
State of Ohio versus Tricia A. Yeager, case number CRA 25-314. She has been picked up by Green County, Ohio.
This is State of Ohio versus Tricia A. Yeager, CRA 25314. This has been reported, Mr. Hill, that she has been picked up by Green County, so I presume you're moving to dismiss.
Yes, Your Honor.
All right. This matter will be dismissed at state request.
Thank you. State of Ohio versus Danny Sellers, case number CRB 24504. This is Justice Stiver's case.
All right, this is State of Ohio versus Danny Sellers, CRB 24504. Mr. Sellers, Danny Sellers. Mr. Sellers is not present. His attorney, Mr. Steyer, is. State represented by Attorney Philip Hill. And for the record, I believe, from memory, at the most recent traffic court night, Mr. Sellers failed to appear on a driving under suspension charge, and there was a bench warrant issued over that.
Your Honor, this was a 90-day continuance at one time that had come back in January and then fell off the docket due to an alleged non-appearance. I think Mr. Sellers had been picked up, released, and we're back here. I assume court costs have not been paid?
I can't tell in this room, but they can check with the court office.
Okay. I didn't realize that wasn't available information here. I don't know whether the costs have been paid then.
Do you want, well, does that change anything for you, Mr. Hill, if the costs have been paid?
If the costs have been paid, we can go ahead and dismiss it.
All right, why don't we do this? Let's just recall this and deal with what Mr.
I'll take a look at it, Your Honor.
Check if it's,
I'm looking at the docket, I'm sorry, you did not.
okay. Well, in looking at the document, it appears it has not been paid.
Okay.
We asked for a bench warrant. There's already one, I guess, from the other case, but we asked for one.
All right. Based upon Mr. Sellers' failure to appear, he was scheduled to be here at 10 a.m. It's now 11:49 a.m. Be a bench warrant issued.
There's so many files we still have to go through.
5 versus Patricia Evans, case number CRB 19678. Mr. Morford's case set with expungement.
So the State of Ohio versus Patricia Evans, CRB 19678. And as Evans is here, is Mr. Morford's case. Is Mr. Morford still in the building?
His files are here, so he should be here, Your Honor.
Okay.
He's here.
Thank you. We could have Mr. Morford in the courtroom. All right, Mr. Morford, this is Patricia Evans. It's a sealing of records that I believe we had you down as.
Yes, Your Honor. I haven't heard any objections from the state. I believe she is qualified. No offenses would disqualify her.
Your Honor, we received correspondence. Of course, one of the duties of the state is to inform the alleged, the victim in any case like this of a motion of this kind. And we got a response from the victim, and he is opposed to it. It's not an automatic right. The state has the right to object, and the court, and if the court believes that it is against the public interest, I don't know if that's exactly the wording, but something of that nature, that there's a reason why it's not a good idea to expunge a record. So we would be opposed to it, and if we need to have Mr. Wells here for a hearing on that matter, we could provide him at a later date.
So, Mr. Field, are you aware that statute has changed?
I'm sorry, the statute has
The
changed?
statute has changed. So the way it works now is the request is filed to seal the record, provided to the state. The state has 45 days to file a written objection. And I will give you guys the opportunity if you want to take the time to look at that. But my understanding of the new statute is that if a written objection is not filed within that time frame, it is waived. But if the state wishes time to look at that, I will certainly give it to you to look at that, because if I'm incorrect on that, I want to make sure that we do this correctly. But that is my understanding of the statute.
Okay. And I assume the statute would also require that the applicant serve notice of the motion and a copy of the motion upon the state.
We did that.
Why don't we do this? Let's recall this at the end of the docket. That way it'll give you guys an opportunity to talk a little more. Maybe you can pull the statute. If you pull the statute, everybody agrees, then we can resolve it today. If not, if everybody wants time or wants to brief the issue, I will certainly allow that.
Thank you, Your Honor.
Right, let's recall this a little later in the docket.
State of Ohio versus Joseph Barber, case number CRA 24679A and B, and CRB 24680.
Judge, if you don't mind, I'm going to stop right here and get the file.
Sure. This is State of Ohio versus Joseph Barber, CRA 24679 A and B. Mr. Barber's present with his attorney, Mr. Morford. Mr. Morford stepping in to get his file. State's going to be represented by attorney Philip Heel. And this matter says a preliminary hearing.
It just says you don't have it, man. 666.
Couldn't have checked over your file. make sure you was okay. I stopped down at the courthouse, see you was okay. I think I put you up.
Judge, do you have a report from RRS after April 25th?
I do not. I think there's a record of RRS here, but I just want to.
I believe it's coming momentarily. Sir.
Already? Yeah. I'll take care of all that stuff. Yes, sir. That's the number. With that string this morning and stuff too.
All right, very good report, Mr. Barber.
Thank you, sir. Judge, I would assume you're going to set this out for a while. Could we give maybe 2 months? He's doing well. He's been in this for a number of months.
Since October.
And since October. And he's even already been seen at RRS this morning for counseling and screen. So he's taking it serious and would like to go out just a little bit more than a month or so.
Excuse me.
Any objection to that, Mr. Hill?
No, Your Honor, we just need a time waiver.
But we'd wait time.
I'll find that the defendant has waived time. Let's go out to August 18th.
Okay.
10 a.m.
Thank you, sir.
Thank you.
State of Ohio versus Aaron K. Wells, case number CRB 25220.
This is State of Ohio versus Aaron K. Wells, CRB 25220. This matter was scheduled for a trial today. However, I cannot hear this case as I presently represent Mr. Wells, and so this matter is going to need to be rescheduled. Mr. Morford, are you representing Mr. Wells?
No.
Okay.
No, I was just wanting to see if you had anything to say. Thank you, Judge.
Mr. Hill, how's your schedule for June 16th?
Is that Friday, Your Honor?
That is a Monday, I believe.
We need it to be a Friday. We need it to be a Friday, Your Honor.
Give me one moment. How about June 27th?
We can do that, Your Honor. And we have two witnesses, so we will have to make sure that they're both able to be here on that day.
And we're going to schedule it for noon on June 27th for trial.
Thank you.
State of Ohio versus Carla Eastet Parsons, case number TRC 154712, CRB 15995. Your Honor, there's some getting like callers and stuff. I should have been called for some reviews.
Okay. This is State of Ohio versus Carla Eastet Parsons, TRC 154712 A and B. And it looks like the 15995 has been closed. This is Steph, Ms. Parsons is present. And it looks like you're down to $352 is all you got left.
Yes, sir.
You've done a substantial amount of community service. I closed your other case out, so I applaud you there.
Thank you.
You could do basically, if you want to do 7 more days of community service, you have all but $2 paid off.
Really?
So you're certainly welcome to do that, it'll save you some money.
Yeah.
And so if you want to do that, we should do that, show up for community service or see probation about doing that.
See probation.
And then let you work that off.
Yeah.
I'm going to set you another review hearing.
Okay.
In this matter. Or, I don't believe the warrant went out, but if one did, I'll recall the warrant.
Okay, thank you.
As a precaution. And I'm going to set you another review for July 28th at 9 a.m.
All right, thank you.
And you have everything paid off and taken care of by then, you do not need to appear, but make sure if you do, you verify that with probation to make sure.
Okay.
And we'll pull it.
Okay, thank you.
Thank you.
Your Honor, we're ready to go back to Lawrence County Jail. State of Ohio versus Tustin Pelcher, case number CRA 25333A and B, and TRC 251265.
All right, State of Ohio versus Justin Belcher, CRA 25333A, B, and B, TRC 251265. We're recalling this matter. Mr. Belcher is present via Zoom. His attorney, Mr. Steyer, is here today. We're having Mr. Belcher assessed for possible treatment.
And Hometown Recovery spoke to Mr. Belcher, but he has Western Union Medicaid, so they're unable to help him. They asked to have OVP speak to him, but I don't know if Mr. Minute is still here.
She is not, she left. They're supposed to give me a report. I've been dealing with something in here that I haven't looked at, Your Honor. I'll look see if she texted me anything in just a minute.
All right, thank you.
Sure. All right, Mr. Belcher, have you spoken with OVP this morning?
I've spoken with someone, I'm not sure it was OVP.
Okay.
Have you spoken to more than one person?
No, sir, I've only spoken to one.
Then OVP probably hasn't actually gotten a hold of him yet.
All right, why don't we do this? Let's pass this one again. Briefly, we'll have you back out in a bit, Mr. Belcher. Once we determine if the right person has spoken to you at that time.
I haven't seen from OVP yet, Your Honor.
Are we sure OVP has been notified?
Yeah.
Yes. Before Brianna left, she said that they were going to be calling and doing an assessment, and she would let me know.
State of Ohio versus Tara Kurd, case number CRA 25332.
All right, this is State of Ohio versus Tara Kurd, CRA 25332. Ms. Kurd's present via Zoom. Her attorney, Mr. Roger Smith, in the courtroom, and I believe we may have an assessment.
We have, and we do have a bed available for her, and we are willing to accept her in our program. I do believe that she needs an ankle monitor.
Okay. Ms. Kurd, did you hear what the treatment recommendation was?
Yes, I did.
All right. Are you willing to go into treatment?
Yeah.
All right. So, Mr. Smith, I presume you're requesting a bond modification?
I am just to know our bond release only to Bethesda, subject to her being placed in ankle monitor, which it's Friday, I don't think we do that today, hopefully.
Not looking good with what
Yeah.
we had earlier, but Mr. Hill, any objection to that?
No, Your Honor. We need a time waiver.
I'll execute that.
All right. So I'll find that Mr. Smith has waived time on behalf of his client. I'm going to amend the bond to a $2,500 OR bond with GPS monitoring and release only to the treatment provider.
Thank you, Your Honor.
Thank you, Judge.
When we come back on.
Oh, yes.
Oh, we need to set a new date.
Yeah, the new date.
I don't want to go too far out on this right now because of where she's currently incarcerated.
I'll have to look, every Monday and Tuesday and Wednesday this month, I have jury trials. Starting this month, I know I'm here the 27th, I may have a Monday if I could look.
Is that all?
Well, the next three I know I don't have.
Is that all the jury trials you have?
Well, I've got, Monday, Tuesday, the 16th, 17th, 18th, I got a jury trial, then the 23rd and 24th, and they are all going to go. But I might have a Monday that I can find.
One of these days are going to keep you busy.
Well, yeah, I've got a bunch on Friday the 13th, which is a week from today. We could,
That'd be fine.
if I got 12,
let's put
13,
it
it's
on.
all the same.
Let's put it on for 6:13.
I can do that.
Preliminary hearing, 10 a.m. Just have to check out, and then that way we'll know whether we can get a monitor by that point. And
Should be on the list, Your Honor. We have 10 of them out that I'm aware of now. We think Mr. Dawson's next on the list, it should be after him.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
State of Ohio versus James DeMint of the Lawrence County Jail, case number CRA 24290, CRB 24635, CRA 24786, CRB 24787, A and B.
All right, this is State of Ohio versus James DeMint, CRA 24290, CRB 24605, CRA 24786, CRB 24787, 231859 AD, Mr. Tyler Smith's case. We're recalling this on the matter of treatment. And did you have an opportunity to speak with Mr. DeMint?
Yes, I spoke with him, and we can accept him into our program. We can pick him up today.
Mr. DeMint, are you willing to go into treatment?
Yes, actually, I was for sure.
Probably a good choice.
Yes.
We're going to get you out today, James. Well, I think it's probably better if we don't talk.
Yes, sir.
Okay.
I was too quiet.
Mr. Smith, I presume then you're moving to modify the bond?
Yes, Your Honor. He has been in since May 5th, so technically he's been in 32 days. I think it's appropriate now for him to go into treatment since he's willing and they're willing to take him. We asked to amend the bond so he can be released.
Mr. Hill?
We're not opposed to that, and I just want Mr. DeMint to know that we really wanted to stick this time. I was looking at how many pages of notes I had on his cases, and I'm ready to, I want to close this file sometime. And ordinarily, I'd even consider needing a GPS monitor, but he's already been sentenced to, I believe, a year in jail. So that's good enough for me, and I just want him to know that I would never want to see that happen, but, I mean, he could go to jail for a long time if he doesn't make this happen. And the reason we put that in place is to make a constant reminder to him that he needs to get it done, and so we don't have to look at doing something like that.
Mr. DeMint, did you hear what Mr. Hill just indicated to the court?
Absolutely. I thank you, Mr. Hill.
All right, we'll do it, okay?
Mr. DeMint, I'm inclined to give you that opportunity, and I'm inclined to do so because of the amount of time that you've spent without an ankle monitor. But I'm going to go ahead and tell you now, you're going to have 333 days reserved over your head that you could go back to jail for if you don't complete your treatment, you get in further trouble. And so you got a long time hanging out there. So I'm going to give you a chance. Don't let me down. Okay? All right. I'll grant that your judicial release out of the jail today. I'll reserve 333 days of credit. There was 365 imposed. You'll get credit for the 32 days that you've done, which will leave 333 days remaining. And you're to be only released to hometown for treatment.
Your Honor, may we approach real quick?
You may. After a brief bench conference, I was informed that my math may be a little incorrect, which is not surprising. So, Mr. Dement, what I'll do is I'm going to impose the 6 months on count 1, the 6 months on count 2 that you're already sentenced to, give you credit for your days off. It was 180 days and 180 days, so I was basing it on 365 rather than 360 that you were originally sentenced to. So there'll be 328 days reserved. So you'll get credit for, so you'll have 328 days reserved instead of the 333 that I originally said. And you'll only be released on town recovery for treatment. I'm going to give you a review date. I don't want to go far on this based upon the history here. So I'm going to put you on for review June 16th. To make sure that you're in the program and that you're doing what you're supposed to do. And that'll be at 9 a.m.
Yes, sir.
All right. Mr. Dement, that'll be the order of the court. You'll be released to treatment as soon as they can pick you up. And we'll see you back on June 16th at 10 a.m. And
9 a.m.
Oh, excuse me, 9 a.m. Correct. 9 a.m. and do what you're supposed to do here. We don't want to have to put you back in jail and keep you in there for long.
Yes, I'm doing here, can't get here, please.
All right, perfect. We'll see you back then on June 16th.
Shot for that helps. Thank you.
Thank you.
Thank you, Your Honor.
Okay, thank you, Your Honor.
State of Ohio versus Joshua Burrell, or Bureau, case number CRV 17169.
All right, this is CRB 17169, State of Ohio versus Joshua Morrell. Was Mr. Morrell ever screened?
I couldn't use that.
All right, well, we're going to recall this matter and we're going to wait it out. And if by the end of the docket you can't use the bathroom, then we'll reset this for another day. So we'll recall this later in the docket.
Just, has everyone asked you questions? I mean,
State of Ohio versus John P. Ramsey here at the court. Your Honor, this is case number CRV 25107 AMD. He was to have reported today here by 11 o'clock for jail, and he has done so.
All right, this is State of Ohio versus John P. Ramsey, CRB 25107 AMD. Mr. Ramsey had a report date for today. He has reported for incarceration, and so the matter will be passed at this time.
So misdemeanor. Yeah. That's right.
State of Ohio versus Nicholas Atkins here at the court, case number CRA 24294, CRB 24295, CRB 24293.
All right, this is State of Ohio versus Nicholas Atkins, CRA 24294, CRB 24295, CRB 24293. Mr. Atkins is present to the attorney, Mr. Rogers, State represented by Attorney Phillips.
Judge, last time we were here, he was at St. Mary's Hospital. Obviously, he's been discharged. He's having, the best way I can word it, insurance problems with, you've got Washington Insurance now. He can explain probably.
Again, I started work. I did good until I went back to work. Then I had insurance issues. I had to get private insurance through my work, and then I started running into issues affording co-pays and stuff like that. So I ended up running out of one of my antidepressants and started detoxing off of that, and that makes you have pretty crazy thoughts. So I had to go check into Highland Hospital in Charleston, and now I'm here, and they helped me get West Virginia insurance back.
Okay. Mr. Smith, what's your pleasure?
Judge, I don't know the structure who takes West Virginia insurance. I know OVP does, but I don't know.
He was with OVP doing outpatient.
He was, and I misspoke when I said St. Mary's, it was at Highland in Charleston. His dad's been communicating with me, his dad's very concerned about him. He wants to be in treatment, he's not willfully.
Sure.
It's just sometimes it's bad to have insurance, which sounds weird to say, but in some of these cases it is.
It's unfortunate,
Private
but
insurance.
sometimes there's a penalty for working. So,
Doing what you're supposed to do. But I would like to see him get back in treatment. I don't know if Bree has left yet or.
I can take him, but I have
Okay.
to switch his insurance. What do you want to think? Switch it.
You okay with that?
I think I'd rather him go back to, we've had enough insurance issues, I think switching the insurance.
This is the second or third go-around with, they limit his numbers of, yeah.
If OVP will take him back, because he was doing outpatient, so I presume
Yes.
OVP will take him back, because it
Yes.
doesn't sound like it was a compliance issue. It's
No,
something
he's
with
working, he
insurance.
wants to be back in treatment. He just needs help getting there.
All right, so, Mr. Atkins, I'll let you go back to OVP, but you're gonna have to, we don't have anybody here presently for you to meet with, so that's gonna be incumbent upon you to go and take care of it.
I will be here next Friday. I know it's a big, but at this point, 14 cases, 13, it's all the same. Make sure he's gotten in with OVP just to keep.
Let's go a little bit further out on that, just because
Even better.
I'm concerned that he may not be, if he calls for the appointment, it may not be.
Yes, sir. I've got the 27th of June or the 7th of January, or 7th of July.
Let's do the 27th of June.
That's 3 weeks from today. So if we don't wait till the day before, so you can't do it till Monday, June 27th. It's 3 Fridays from today. Make sure, yeah, by Monday you get hold of them, get set up so you can show them your back end and do it June 27th. All right, thank you, Judge.
Thank you.
State of Ohio versus James P. Badgett, case number CRA 2525 A and B.
State of Ohio versus James P. Badgett, CRA 2525B. Mr. Badgett's here with his attorney, Mr. Tyler Smith, state's represented by Attorney Phil.
Must have sent here.
I got it. I had another long time to slip up, but I've been doing good. They're cracking the whip on me.
Yeah, I don't.
Additional sex.
Reset it.
Okay.
To get a report. Your Honor, normally I get a report via email, but I haven't received one yet. I think maybe we need to just set a date, maybe next Friday. I'm here. If we can do that, or we can do it in, I'm also available June 23rd or 27th. I don't know if the court's received one recently.
Where's he going?
ARC.
I do have a note that there was a positive screen back, and I think that was back.
Yeah, that was the last time we were here. We had
time we were here in
that.
April.
Yeah. But he's still continuing with his treatment. We just need to get a report. Normally they'll email the report to me and I'll make copies for everybody, but I haven't received one. I was checking Mr. Badgett if he had one. He doesn't either.
In fact, can I speak? I talked to her this week. I thought she sent something out. Her name's Mannon, or maybe it's William Preston, maybe it's one of those two, but
it's okay.
but I don't get those. I apologize.
I know. Normally she does. It's just, I didn't get one this time, so I was hoping maybe you had.
Let's come back in a week.
Okay, the 13th, 10 o'clock.
And I'll go ahead and put it on you as well, Mr. Badgett. It'll be incumbent upon you to bring a report.
Okay.
That you know how long. Okay.
Yep, thank you.
Sorry, thank you. 10 a.m., June 13th.
10 a.m., yes, sir.
See you then.
I think so.
State of Ohio versus Michael Brown, case number CRA 2540. Mr. Stiles' case.
Michael Brown. The State of Ohio versus Michael Brown, CRA 2540. Mr. Steyer is present on his behalf. Mr. Brown is not present.
This is another case that we previously had a lapse in attendance. But I believe the state had perhaps subpoenaed the victim to be here today.
We did request a subpoena, I believe, yeah. And so I don't know whether she was actually served or not.
Julia Hill.
We've not only done that, but attempted to reach her by telephone, and we've left a voicemail and didn't get a response.
I would ask that even though it's unusual to do so when the defendant isn't here, maybe this is one that the state might want to nolly and refile if they get contact with the victim.
If she's been served with a subpoena, for sure.
I don't have any idea if she was served or not. Let's see. Oh, wait. I don't believe this was valid service on it, but it was served on 5/14 by leaving a copy at the place of residence. That wasn't personal service on it.
They just left it at the door.
Yeah, I don't understand that, but, so we're going to nolly it without prejudice.
All right. To nolly with the right to refile.
State of Ohio versus Robert Irwin, case number CRA 25-278, CRB 25-279.
Corinthia Crawford. So,
All right, this is State of Ohio versus Robert Irwin, CRA 25-278, CRB 25-279. Mr. Irwin's present, please turn to Mr. Steyer.
Your Honor, Mr. Irwin is going to waive his right to preliminary hearing this morning in order to maintain his bond. The state had asked that he get in addition, had asked that he get an assessment for substance use disorder and mental health. He's scheduled both of those with RRS.
That's correct, Mr. McKeon.
That's correct.
All right, Mr. Irwin, you have a right to have what's called a preliminary hearing to determine probable cause. Your attorney's indicated that you're willing to waive that in exchange for, I believe, keeping your bond.
Yes,
Is
sir.
that correct?
Yes, sir.
And you wish to voluntarily waive that right?
Yes, Your Honor.
All right. I'll accept your waiver as known and voluntarily given. And this matter, once everybody signs, will be bound over to the Court of Common Pleas for further consideration by the grand jury.
Understood, Your Honor.
If there's any misdemeanors, which I believe there is, we would, aggravated menacing, we'll nolly that to the grand jury.
All right. That will be so nolly.
so that's what that meant.
Yeah, sign up there, right there. Okay, Mr. Irwin has signed the waiver, if I can bring it forward.
You may. Matter be bound over for further consideration by the grand jury.
Thank you, Your Honor. Yeah, there's no date for that.
So you just serve me?
Yeah.
Thanks. Okay. Have a good day.
We're not there to the answer. I'm right.
Oh my God, so how do you do copy and paste for me?
Well, I just wanted to have it for now, just so I can speak intelligently if I needed to.
State of Ohio versus Gary Kazoo, case number CRA 25-53, CRB 16-166, CRB 14-309.
State of Ohio versus Gary Cassey, CRB 25-253, CRB 16-166, CRB 14-309. Mr. Cassey is present with his attorney, Mr. Steyer. State's represented by Attorney Phil.
I believe this is another where the state was attempting to get the alleged victim here. I don't personally know the alleged victim, but I don't believe she's here.
Emily Markham.
No, she got served.
Now, just, of course, we don't know if she got served or not.
It appears, well, the note that I have here from Deputy, looks like Terry Adkins, was on 5/24/25 at 7:15 a.m. was moved / evicted, unknown new address. So it does not appear that she had been served.
All right.
But it does not appear that she lives at that address any longer.
It's only difficult to do. Keep it in there, take it to grand jury, because I can't subpoena her. So subpoena says.
At least that's on the CRA 25-263 case. So I presume that's what you're looking at.
She's new. No, new 40.
All right, so what we'll need to do is nollie this case, and we may continue to try to locate her. And if so, this is a felony charge, so we can take it to the grand jury. In order to resolve it in such a way that Mr. Z would not have to worry about going to the grand jury and risk going to prison, if he were to enter a plea of guilty to the misdemeanor charge today, we would recommend a suspended jail sentence.
So what he's suggesting is,
Well, suspended jail time, so you can be on probation for long to get a trial. Your Honor, he maintains his innocence. We are willing to waive the time constraints to give the state another chance to try to get a hold of the victim, if that's a possibility. If the state just wants to go ahead and nollie the charge with the possibility of taking the grand jury, they can do that. But again, we're willing to give them some more time to keep the matter here.
Okay, we'll do that.
All right.
So-
How much time do you need, Mr. Hill?
2 weeks, Your Honor, or whenever it's convenient.
2 weeks, I'm on vacation, but I am back here the 27th, which is 3 weeks.
All right. Defendant's request, we'll do June 27th, just preliminary hearing, 10 a.m. To give the state an opportunity to attempt to locate the victim. That's better for you.
I mean, I laugh, that's true.
That's exactly what happened.
Thank you.
State of Ohio versus Billy E. McKenzie, case number CRA 24-497, A and B.
So we come back June 27th.
Okay. 27th.
27th.
Okay, at least the 22nd, I was sure.
But thank you, though, because.
Okay, sorry, I missed.
No, because I'd rather you tell me. Because I'm so crazy.
Me too.
June 27th.
Before we go any further, Mr. Irvin.
Yes, Your Honor.
Robert Irvin, he waived this preliminary, didn't he?
He did.
Okay, this is what
He waived one charge, but then
There was a misdemeanor that got nollied to the grand jury, if that's the issue.
is that not the right form?
Misdemeanor one. Which one was that? Actually, both of these need to be read. The CRB one case, CRB 25279 should just be, okay, never mind. That one's fine, but there's no nollie on the CRA. That was just a straight waiver. So the B case is fine.
Okay. You can run over that.
which we've done the waiver, so I don't think you should have, you don't have to do anything else, I believe, with the CRA, because he signed the waiver, so.
So you think we're okay?
We're okay, we just don't want to file this.
Okay, all right. This one is okay, correct?
Correct, yes.
So, Your Honor, Mr. McKenzie, I have confirmed, is currently housed in the Scioto County Jail, not on these charges, but on some other matter. I think the state's pleasure is a warrant so that when he's released from Scioto County, we can get him back down here.
Mr. Hill?
That's correct, Your Honor.
All right. The bench warrant issued for Mr. McKenzie for failure to appear, based upon him being housed in the Scioto County Jail.
Thank you.
Thank you.
State of Ohio, Charles A. Hardy, case number CRA 25233 A and B. It's Mr. Morford's case.
This is State of Ohio versus Charles A. Hardy, CRA 25233 A and B. Mr. Hardy is present with his attorney, Mr. Morford. The state is represented by Attorney Bill Hewitt. Matter is set for a pretrial and preliminary hearing.
Erica Ferguson?
Your Honor, if we're ready to proceed, we were here previously, and the young lady who's allegedly the victim in this signed a statement, a notarized statement, that none of this happened the way that she originally said it happened. We're not satisfied with that as a final explanation or a final decision-making statement by her, and so what we want to do is have her present and have another hearing and have her state on record what her feelings are about this.
Mr. Morford?
Judge, we had an objection to that.
All right. Mr. Hill, when do you want to come back?
The 27th, we're going to issue a subpoena.
All right. Mr. Morford, you're available the 27th?
I am, Your Honor.
All right. At state's request, bring him back June 27th, the preliminary hearing and pretrial, 10 a.m. So I'm making a note for the victims to be there.
Thank you, Your Honor.
Thank you, Mr. Morford.
State of Ohio versus Joshua Morrell at the Lawrence County Jail, case number CRB 17169.
Mr. Morford, come around here and report for a second.
Yes.
All right, this is State of Ohio versus Joshua Morrell, CRB 17169. We're recalling this matter after Mr. Morrell was screened. Mr. Morrell, are you presently working?
I was working at Taco Bell, but I got fired for talking back to one of the managers, and she said if I still work there, she was going to quit, so they chose her over me.
Okay, so you're not working currently?
No, no.
All right, what I'm going to do is I'm going to appoint you an attorney, Mr. Morford, to represent you. And I'm going to give him an opportunity to review the file here, and we'll reach out to you at the jail here if he wishes to speak with you. And then we're going to recall it again now that we got the results from your screen. But I want him to be able to review that, have an opportunity to speak with you before we go forward. Okay?
Yeah, but, well, I got your question. You said I'm on probation. I'm not giving that before, man. I'm not trying to, like, run these problems.
I'm
It never said I was on probation.
going to let you talk to your attorney about that, okay? I can't give you legal advice. The
But you're not
information,
having some kind of bad charge on that. I think got probably a week old back in 2019.
the information I have in front of you was the 2017 case of drug paraphernalia, and that you still have a balance and you're still on probation. So I'll let you speak with your attorney about that, and then we'll have you back out here in a few minutes.
Sir, don't interrupt the court when the judge is speaking.
Mr. Morford, if you would approach, I'll go ahead and give you the file. Let me know whenever you're ready to have a recall.
I'm going to call you right now, sir. Thank you.
Thank you.
State of Ohio versus Holly M. Lewis, case number TRC 25956, A, B, and C. That's Mr. Steyer's case.
So State of Ohio versus Holly Lewis, TRC 25956, A, B, and C. Ms. Lewis is present with her attorney, Mr. Steyer, who's walking in the courtroom now, and the state's going to be represented by Attorney Philip Field. And I presume we have a treatment update report or some sort.
Of some sort, Your Honor. Due to some insurance issues, we're having difficulty getting her started. She
was a resident in Jersey, New Jersey. Now she's a resident here, so we're just getting that split over.
Okay, so we got to get that switched over. She has her assessment scheduled for when?
The 11th.
For the 11th. So we need to come back a date after that. We would waive time constraints to accomplish that. After the 11th, I'm here the 13th and the 16th, and then I'm not going to be here again until the 27th.
All right. 13th is getting a little crowded, but we need to get, well, you said you could do the 16th?
I can do the 16th if that's
All right,
better.
let's do the 16th. So defendant's request, the pretrial and preliminary hearing, 10 a.m., June 16th.
And there is the matter of the OVI that's pending, so we'd like to have an idea of whether they want to contest that or whether they are willing to concede that in order to get some extra consideration on the felony charge.
Let's see if we could see where the assessment leads us and then discuss that matter.
June the 16th?
June the 16th.
All right, June 16th, 10 a.m.
All right, thank you. So I'll see you then. Thank you.
Thank you.
State of Ohio versus Michaela Wells, here at the court, case number CRB 24657. The artist is set for sentencing.
All right, this is State of Ohio versus Michaela Wells, CRB 24657. Michaela Wells.
She's actually working. She still resides with us in sober living. We were waiting for her CPS case hearing, and we thought it was in June. It's actually July.
Okay.
She's compliant and doing well.
It's a good report. All right. Mr. Smith, you wanted to come back after, you know when in July that is?
I believe it's the first week of July, around July, this same date. I just think we got the months mixed up.
Your Honor, that's fine. We can come maybe the second week of July, just to make sure it's, we'll CPS it.
Are you around July 14th?
That's fine, Your Honor.
July 14th, at defendant's request, proceed.
Thank you, Your Honor.
Thank you. Thank you.
State of Ohio versus Robert A. Hill, case number TRD 24335. Your Honor, this is also set for sentencing. Robert Hill.
The State of Ohio versus Robert A. Hill, TRD 24335. Robert Hill. Time is now 12:40 p.m. Mr. Hill was scheduled to be here at 11.
Yeah. Western Regional Judge.
Failure to appear. Bench warrant issued.
Your Honor, the only two cases we have left are the expungement, and that needs to be explained to Mr. Moore. And we have Justin Melcher at Lawrence County Jail, but we have not yet got the report from ODB.
Okay, well, let's take a brief recess then while we wait for those to happen so that we can then proceed. Please recess.
We do Justin.
I don't think so, unless that before we can.
Freddie Adams.
Thank you.
Senator, I'm going to ask and see if this is for today.
I don't have any defense to this. That's one thing we have to tell the victim when there's been a motion to seal records.
I didn't know about until I get the docket this week.
I'd like to know when
and
we got this.
I don't know, it was in the, you know what I mean, it was with the files.
Yeah. Who got the letter? Did Missy get the letter?
Missy said it was in her box this morning over on the court
This
side.
morning.
And that victim left me a voicemail yesterday and said they were dropping off something for you and the judge this morning.
All right.
So they must have dropped it off this morning. And they were aware of the hearing. I did was not. So I guess from now on, if it's a victim case, whenever we're served one, we need to know right ASAP. Because they've changed the thing on it.
Yeah.
I'm gonna find out what happened with Freddie Atkins.
Are you checking on that expungement stuff?
Yeah, I don't have a defense to it, so.
Yeah, that's what we're working on.
Yeah. I can, on Westlaw now, you can just ask it a question and it spits out.
Oh, that's good. That's an AI for you.
Yeah, it's like 20 pages of like cases and all kinds of stuff. I've looked at it enough to know that I don't have a.
Okay. And Jasmine handed me a couple of papers. One of them, I think, is probably yours. You need to have.
Yes.
Let's see. Tom, you good?
Thank you. Yeah, I found this out in my office the other day, and I was like, oh, this will go with my shoes.
You're a busy man.
It's, you know, you lose track of time too when you're sitting there for 34 hours in a row. Worn out. Luke, texted me, where's he now?
Whatever, man.
Luke, I appreciate it, man. You send people to us. I really do appreciate it.
He's basically trying not to root him to Bethesda. That's my main.
I don't know if you've been in business for about 10 years now, but we're out here in the Chesapeake area. We got 6 houses. We got one facility that can hold 36 clients.
Oh, wow.
Yeah, so there's always a bed.
A lot of capacity.
Yeah. We had it built about 5 years ago, and it's a 3-story facility, it's laying in the house. Do the outpatient for females and males. It's just regular. We are one of the only outpatients really that transport. A lot of people have a problem getting to their appointments or groups with therapy.
I didn't know you guys outpatient
transport.
transport.
Outpatient.
I didn't know that. That's good to know.
It's Southwood, Chesapeake, and Orange County.
That makes a pretty big difference.
And we started a new thing, it's a domestic violence group.
Yeah.
And our clinical director came in here and he pitched out a capital. He was pretty interested in it. See how that works out.
I was brief. I did too. And I just called her back. They were on hold for about 20 minutes and the guy got on there and said, you better call back. So I don't know what's going on. So they've not done the assessment yet.
I would be a Monday.
Yeah, I mean.
Just let you know, I just called off on Marina. They called down on hold.
he printed that.
Okay, I already did.
That Freddie Atkins was dismissed back in May. Yeah, someone dismissing this. I just checked with Clarissa. June 6th, I'm dismissing this protection.
This is what they're discussing.
Yes.
Okay. It's trash. I'll put it in there. Okay.
And they're waiting for somebody to pay.
Oh, are they? These are. I'm gonna try it on the side.
I have no idea
About
until,
them?
I don't know if they even called up.
It didn't. I'll go ask Clarissa.
Okay.
Oh, okay, Belcher and Merle back in the chair for us. Belcher and Merle. That's all right. All right.
I serve at your pleasure.
You know, I don't represent you in this expungement, but I didn't have anything to do with that. Well, he's gonna call that, we're gonna get that straightened out. And I don't know what Mr. Gill will do.
Lawrence County Municipal Court is now back in session. State of Ohio versus Patricia Evans, here at the court, case number CRB 19678.
All right, this is State of Ohio versus Patricia Evans, case number CRB 19678. We had called this case earlier, and the state had indicated their intent to object to the sealing of records. I believe Ms. Evans is here presently with Mr. Morford. And looking at this, Mr. Morford stood up, but he was on the original case, and this appears to be a self-filing. So first off, Mr. Morford, are you intending to represent Ms. Evans?
No, I've not been retained to do that, Judge.
Okay.
I did represent her, as you noted, on the underlying offense.
Okay. And I guess technically you've represented her at some point today during the pendency of this, but you're
Yes.
asking to withdraw.
Yes, I am.
All right. I will allow Mr. Morford to be withdrawn as counsel of record at this point. Ms. Evans, we discussed, I believe, the statute and some of the circumstances behind that statute, and I believe Mr. Hill, have you had an opportunity to look at the statute and look into this a little bit further?
Your Honor, in the interim, since we last spoke about this on the record, I did have a chance to research the issue and also the filing. And I do note that the state was given notice of today's hearing way back on April the 24th. So in looking at the statute, the requisite amount of time has elapsed for the hearing and the time has passed for an objection. One thing that I will note is that we did get a letter from the victim in this matter asking us to oppose the sealing of the record. And we intended to do that, but are out of time to do that.
If you wish to read the letter into the record, I would have no problem with that.
This is from Bradley Wells. The event in which the assault was committed was at my child's school where the children were present. This has had many negative impacts on my family. My small children were attending their school's open house when she became physically aggressive and punched me in the back. My children still remember this incident clearly and admit that it made them fearful. Although physically, other than marks on my back, I was okay, the mental health of my family has been deeply affected. I'm currently in counseling and prescribed medications for anxiety. I feel as if I'm in a constant state of hypervigilance after this incident. It is my request as a victim in the assault case taking place in 2019 that Patricia Evans' records not be sealed. The children have remained in my full custody the past couple of years. Patricia will display appropriate behavior and the ability to get along for a couple of months, then have a sudden switch and go back to violent threats from herself or the men she involves herself with. On different occasions, she has had two different men state that they would come to our home and kill not only my wife and I, but also the children. This has been documented. My hopes are that due to her unpredictability, that this court will find that the sealing of the records is not just or acceptable. Thank you for taking the time in consideration of myself and my family. Bradley Wells.
Okay. Anything further, Mr. Hill?
No, Your Honor.
All right. I'm going to find that the 45-day period for an objection is passed, and therefore under the law would be required to seal this. Additionally, I think it would be appropriate, given that an assault is not a condition precedent offense. So for instance, where if it were, and these aren't available for sealing, but for example purposes, if this was a domestic violence where a second domestic violence results in a felony, or a protection order violation where a second one would result in a felony, I would think that that would be a little different. But additionally, but in this particular incident, the assault charge does not allow for that, and under the law, I think that the objection period is passed and would otherwise be waived. So, Ms. Evans, I'm going to grant your sealing of record pursuant to the statute. However, I do not have an entry, an order here sealing that. It would be incumbent upon you to provide that to the court. The court can't do it for you in this instance. And I can't give you legal advice, so I can't say here's what you should do or what you shouldn't do, and make sure you get this in there or that in there. In the event that you need help with that, you would need to seek an attorney to help you file that final entry that would ultimately seal it. Once an entry is filed, the process is it's then sealed here at the court. Under the court will then remove the records here. It then is sent out to the appropriate agencies that are listed in the order. We are on their timetable for that. Whether that takes them a day after getting it or 3 months after getting it, I can't speak to that. But that's the process as it goes out immediately from here. Okay? All right, that'll be the court's order. We'll be awaiting an entry for that.
Thank you.
Thank you.
State of Ohio versus Justin L. Belcher at the Lawrence County Jail, case number CRA 25-333 and TRC 25-1265.
All right, this is State of Ohio versus Justin L. Belcher, CRA 25-338 A and B. Mr. Belcher is present via Zoom. His attorney is here in the courtroom, Mr. Steyer. State is represented by Attorney Phil Keel. Mr. Belcher, can you hear everything? All right.
Okay, to give Mr. Belcher an update as well as to place on the record discussions that were had.
Hold on just a second. I have OVP on here right now that he is accepted to their program and picked up any time, Mr. Belcher.
Oh, well, that's an update then.
Yep, I did.
Then I would ask that his bond be reduced to an OR bond with release to OVP, and that we set this back. I'm still going to say the 16th just because I remember hearing that the 13th was a little bit heavy. And we'll waive the time constraints to accommodate that.
All right, Mr. Belcher, did you hear what the attorney has indicated to the court?
Yes.
All right. Are you willing to go into treatment with OVP?
Yes.
All right. So here's what I'll do then, Mr. Hill. Any comment you'd like to make on that?
No, Your Honor.
All right. Here's what I'll do. I'll amend his bond to $2,500 OR bond with an order to release him only to OVP for inpatient treatment. And we'll come back June 16th for preliminary hearing, and I'll find that defendant has waived time to make that happen. All right. Mr. Belcher, you'll need to be back here June 16th at 10 a.m.
June 16th?
Yep. You're going to be released to OVP for treatment as soon as they can come and get you.
Thank you, sir.
All right, thank you.
State of Ohio versus Joshua Morrell, or Merrill, case number CRB 17169.
Sure, man. Go ahead.
All right, this is case number CRB 17169, State of Ohio versus Joshua Morrell. Mr. Morrell is present again via Zoom with his attorney, Mr. Morford. State's represented by Attorney Phil Hill. Mr. Morford, did you have an opportunity to speak with Mr. Morrell?
Yes, Your Honor, I did.
All right. What is your pleasure?
Mr. Morrell, I hope I'm pronouncing it correctly, sir, is adamant that he is not on probation. From what I can glean from the court's record, he was picked up on a warrant for failure to appear on a hearing on the last day of May 2024. And I know there was a period of time in 24 that he was going to, I believe, RRS. He's adamant that he's not on probation and that we have no right to hold him or be involved in his life really at this point in time.
Okay. Mr. Hill.
Your Honor, I don't have any records to indicate one way or another at this point.
Okay. Well, we've got Mr. Major here in the courtroom from probation. Is there any, do you want to take a look at the file, Mr. Major? I'll give you an opportunity to address the court.
Your Honor, it appears that his case is not completed. He still owes at least $290 to the court, and it is the court's normal process of not taking people off probation until the case is completed.
Major, I was never on probation with you, ever. On everything I love. I don't mind here, we'll hit nobody.
Let me take a look at the judgment entry, Your Honor.
I never had to check in with you for nothing. I know how you are about checking in.
I would add.
I'm not. Maybe I've known you for a long time, man.
I would add to what I said, Your Honor, that he checked himself in voluntarily for treatment. I should add that.
Your Honor, I don't see any judgment entry in the file.
Okay, we can pull up the...
I'll look and see what it says, Your Honor.
Gotta go way back to get that entry out.
Yeah, there it is. Your Honor, I will say that it doesn't appear that there's the judgment entry says he's on probation, so he's not on probation, Your Honor.
So do we have a copy of the judgment entry in there?
We do not. It doesn't seem like we scanned one in either, Your Honor.
We wouldn't have back in 2017.
Yeah.
Right, it wouldn't be. That would have to be in the file.
And according to the computer, Your Honor, it doesn't say he's on probation.
But it did say her review hearing within 3 months.
Yeah, all I'll have to go on, Your Honor, is what's in the computer, and nowhere in there does it say he's on probation.
But he still does owe money to the court.
Yeah, and it would not exempt him from appearing for review hearings, so.
All right. Give me just a second, Mr. Morrell, I'm gonna go through the file a little bit more here.
I'm sorry about this, Your Honor, I really am. I try not to cause anybody no problem. You know me, you know me for years. If I was, I'd be like, you know what, you got me, but When you said probation, I knew that was wrong. Because now I know how major it is. If you don't check in with him, he's coming after your ass. Trust me, I know my brother Charlie Bucks couldn't stand me.
I've had an illustrious career tonight.
So I hear. All right.
Yeah, you're right. I was going to argue with you at the time. Like I said, I apologize earlier, and
That's not an issue, so here's the issue that we've got, Mr. Morrell. So,
I know I've done a drug test, but listen, I'm not on probation. I don't want treatment. I don't do it every day. I mean, the main day I take is Suboxone, and I get him off the street because I got a medical card. Dude, no rehab right now won't take me because I have no medical
Sir,
card.
I would advise you to not say anything along those lines.
so here's the problem I've got is, this is a case from 2017, and you still owe $290 to the court, and you failed to appear. I mean, there's been numerous review hearings you failed to appear for, but it looks like the most recent one I see was July 12th of 2024. And so when you fail to appear at that time for your review, at that point, you then get a warrant. And that's what you're here on. How many days have you spent in jail thus far?
This one, today be second day.
All right.
I'm being here till my day anyway, so you're going Friday.
So you said you're going to be in here till Monday?
Yes, sir. I ain't going nowhere.
Okay. What reason are you going to be until Monday?
Monday for court for a fight chapter, same thing. I mean, Collins, same thing. They did here.
Okay.
Just the only thing I'm saying is just on day fines. I don't have new charges. I have got.
Here's what I'm going to do, and I think this will make sense. If you got to be there on Monday anyway, I'm going to put you on here Monday morning. And so you'll appear via Zoom here Monday morning, okay? Judge Capper will be back at that time. And then he'll make the final determination on what's going to happen as far as that goes. And if you've satisfied the court at that time, I don't know exactly what he'll do with that, but if you're going to be there anyway, I'm going to put it on for Monday, and then let him take a look at it and see what direction he wishes to go with it. So it's going to be.
Thank you, Your Honor.
No problem. I'm going to set this for June 9th in the morning at 10 a.m. And I'm going to list it as a pretrial at this time, okay?
Okay, thank you, sir.
All right, thank you, Mr. Morrell, and we'll take this back up again on Monday.